Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net.
I'd like to call the meeting to order, the Water Management Board meeting set for May 6, 2026 for the state of South Dakota at the Fort Matthew Training Center. I would like to welcome everyone participating in today's meeting or listening online. This meeting is streaming live on sd.net, a service of South Dakota Public Broadcasting. For the benefit of our online listeners, I request that all participants please identify themselves when speaking during the meeting. Participants should also remember to unmute their microphones only when speaking. The meeting is being recorded and the audio will be made available online following the meeting. To find the audio recording online, do a web search for South Dakota Boards and Commissions portal, follow the link, and select the name of the board. If members of the board's legislative oversight committee are participating in the meeting remotely, please acknowledge your presence at this time. Hearing none, I'd like to take a roll call.
Thomas.
Here.
Dixon.
Here.
Freeman.
Aye.
Kepler.
Here.
Holzbauer.
Here.
Larson.
Here. Do I hear a motion to adopt the final agenda?
Mr. Chair, this is Freeman. Before adoption, at the request of the division, I'd like to amend the 1:30 PM item, consider L2 there, to add to that a discussion of the two-layer appropriation status.
Thank you. Do I hear a second to Mr. Freeman's motion?
Kepler, second.
Take the roll call, please.
Thomas.
Aye.
Dixon.
Aye.
Freeman.
Aye.
Kepler.
Aye.
Holzbauer.
Aye.
Larson.
Aye.
The final agenda is adopted. The next item on the agenda is conflicts, disclosures, and requests for state board waivers. The next item on the agenda is the adoption of the March 4th, 2026 board minutes. Do I hear a motion to adopt that, the March 4th, 2026 board minutes?
Mr. Chair, Freeman, I would move to adopt the minutes.
Do I hear a second?
Thomas, second.
And a voice vote of the members for adopting the adopting the March 4th, 2026 board minutes. All in favor say aye. Aye. All opposed say nay.
Aye.
The next item on the agenda is setting the October 7th and 8th, 2026 meeting dates and location. Anybody have any conflicts with that date on the board? If you- So, okay. So we're gonna set the October 7th and 8th, 2026 meeting at the Floyd Matthew Training Center in Pierre, starting at 9:30 a.m. on October 7th. Next item on the agenda is the public comment period in accordance with SDCL 1-25-1. Do I hear any public comments?
Anybody online?
Anybody online wanna make some comments?
Paul, if you're listening, your microphone is muted if you're trying to make a comment.
Can you hear me now?
Yes,
Okay, so you can hear me? I'm sorry.
yes.
Yes, we can. Please identify yourself.
Okay, good. My comment, and I know I missed the written in comments and stuff, earlier this month, but I wasn't aware of it. I certainly would have, had some comments. So I live on the Jim River, east of Mitchell. And Mitchell wants to drain their water into my river because they don't want it. I don't want the water either. So how can you dump your water on your neighbor's land? And that's all I got.
Thank you, sir. Could you identify yourself for the record, though, please?
I'm sorry, say that again?
Could you identify yourself for the record, please?
Paul Muth.
Thank you, sir. Any other public comments? The next item on the agenda is an update on DANR activities. Adam, you handling that?
Morning, Mr. Chairman, members of the board. I am Adam Mathewitz, Acting Chief Engineer of the Water Rights Program. Few updates. First, obviously, we want to talk about drought conditions a little bit. As of April 28th, 72% of South Dakota is in dry or drought conditions. Pretty much everything south of Highway 212. If you take that as draw a line from the eastern part of the state straight west, it's pretty much everything, a little bit north of that. The State Drought Task Force is kicking off tomorrow with their first meeting of the year. Whitney Kiltz on our staff will be our primary lead with, for representing water rights. We have issued warning letters of low flows for the following surface water sources: Battle Creek in Black Hills, Split Rock Creek over in Minnehaha and Lincoln counties, junior users of the Cheyenne River above the Angostura Reservoir, junior users of Rapid Creek above Pactola. We have issued shut-off orders to users on the Little Missouri River. We are also in contact with the Bureau of Reclamation regarding the various Black Hills reservoir levels and how they've done their fills, and whether they believe they're going to get their annual fill by October 1, which is their water year. So, and that would potentially affect further shut-off orders for users above that. We are looking into that. So, in other news, we as the Water Rights Program have extended SWRMS funding for a few more years. We intend to use that money to install new observation wells in the bedrock aquifers of the Black Hills, as well as the Sioux Court site in the Sioux Falls area. We are in communication with USGS on sites, as well as potential just using some existing wells that they're aware of. So that hopefully we'll be able to save us some money. We're also looking at purchasing some brand new data loggers. Picking the exact numbers is what we're at. We found the devices we like. We just got to go through the operations and maintenance costs to make sure that's within the department budget. The Richmond Dam Rehabilitation Project is expected to start this week. Their issue to start work, I believe, was finalized Monday. And then finally, Ron Duvall. We announced this last meeting that he is retiring. His last day is Friday the 8th, the end of this week. So I'm glad he's wearing a tie and even properly dressed. I was expecting maybe jeans and a t-shirt. But just a little information on Ron and the program that's happened since then. Ron has 43 years total service. And to my understanding, all of it in the Water Rights Program. From a simple technical engineer up to one of our internal legal, I don't want to give him the credit of expert, but knowledgeable person in wisdom. During that time, we've processed approximately 5,500 permit applications through the program. We went from a typist pool to, as you can see, a number of us have laptops now. We went from paper maps to ArcGIS and other high-powered mapping software that we use to determine many things. And, Amanda, do you have it? The picture? Nope. No, the one okay. Well, we had a picture from 1983, 4 months in when Ron started.
Where is it?
Hopefully we can find it. He was a little thinner then. Full head of brown hair, big mustache. As you can see, we got some gray and not a lot of hair on top. So, but we appreciate Ron's service, and, we wanted to give him at least a little recognition in front of the boards. He's appeared pretty much every board meeting for the time I've been here, which has been, more than a decade at this point. And he will be sorely missed by the program, but I did tell him no matter what, I will come to his house if I have to get questions. That is all I have. I am here if there's any questions from the board.
Any questions from the board?
Thank you.
Next item is status and review of water rights litigation.
David McVeigh, Board Counsel. The only thing I have to mention is the program's received a pair of surface water quality discharge permits, and the contested case procedure for that requires a hearing within 20 days of the receipt of the petition. First, it requires the appointment of a pre-hearing chair, and then secondly, the pre-hearing chair hear the petition, or have a pre-hearing conference within 20 days. So we have Rodney as our appointed pre-hearing chair, and discussed the matter with him, and we're looking at scheduling a pre-hearing conference on May 12th at 10 a.m. The program should be filed filing notice of the pre-hearing conference, shortly. So that moves relatively quickly, just in terms of getting that procedure set up, and, that's where we are, just a heads up. And I don't believe we've done a surface water discharge permit in a hot minute. And, yeah, so, anyway, that's what's going on, that's pretty much it for my update. Yep, yep.
Any other updates?
That's it.
All right, thanks, Evan. Next item is to administer the oath to Department of Agriculture and Natural Resources staff.
Each of you solemnly swear any testimony you'll give in the causes before us today will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. All right, next item is the 7-year review of future use permits. Misty Will?
I'm already up here.
Snuck by me.
Good morning, everyone. Amanda Duell, Permitting Administrator for the State's Water Rights Program. We kind of go over this every time, but there are certain entities such as water distribution systems, municipalities, nonprofits, sanitary districts that can reserve water to be used for future needs. These future use permits are subject to review by the board every 7 years. Before we bring these permits for review, contact is made with all of the permit holders, confirming that they do have a continued need and plans to put this water to beneficial use. Based on their response, the acting chief engineer makes a recommendation. Notices are run in the local papers, allowing time for public comment and intervention, and then this hearing is conducted. Today there are 6 future use permits brought for review. Copies of the correspondence, recommendations, proof of publication were included in the board packets, and I did put a note in your board packet that the 2 for the city of Pierre were run as one notice. There were no petitions in opposition or comments received in response to any of the public notices, and it's the recommendation of the acting chief engineer that they all be allowed to remain in effect for an additional 7 years, and we'll bring them back to you in 2033. Maybe not you, but.
Do I hear a motion to adopt the chief engineer's recommendations on the future use permits?
Holzbauer, I make a motion.
Do I hear a second?
Kepler, second.
Thank you. All in favor, say aye. Aye. All opposed, say nay.
Aye.
Hearing none, the motion is adopted. Thank you, Ms. Wall. The next item on the agenda is to consider the petition for a variance from minimum spillway design requirements of the Lake Mitchell Dam.
Well, it's uncontested. Did you want appearances noted, Emily?
Do you want appearances noted if it's uncontested?
Sure.
Emily Greco, Assistant Attorney General, Counsel for the Water Rights Program. Whitney, can you state and spell your name for the record?
Whitney Kiltz, Whitney Kilts.
Can you tell the board,
Engineer with the Water Rights Program.
I was going to say, can you tell the board a little bit about what you do for the Water Rights Program?
I'm a staff engineer with the Water Rights Program, and I specialize in our dam safety items, as well as doing groundwater and surface water permitting.
Now, can you tell the board about what your findings were on the Mitchell variance request?
All right, since we have a busy day, I will keep this fairly brief in terms of a quick summary. The Lake Mitchell Dam is an existing intermediate size Category 1. That's a high hazard dam, which is a dam whose failure may cause loss of life. The dam is located in the northern part of the city of Mitchell in Davison County, and it is on Firesteel Creek. An updated inflow design flood study by Houston Engineering was submitted with this variance request. This updated study indicates the dam can only handle a 23% probable maximum flood event, or PMF. The water rights staff reviewed the study by Houston Engineering and found it consistent with the current best practices for this type of study. Pursuant to the state safety of dam rules, the minimum design flood that an intermediate-sized high hazard or Category 1 dam needs to accommodate without failure of the dam is the 50% PMF event, unless the dam is granted a variance pursuant to South Dakota Codified Law 46-7-5.3. Therefore, the city has requested this variance. For clarification, the 23% PMF event is the current capacity of what's in place at the dam. So South Dakota Codified Law 46-7-5.3 allows for, upon petition to the board by the owner of a dam, the chief engineer may investigate and conduct the necessary analysis to determine the potential damage to downstream residents or property if the dam were to fail due to inadequate spillway capacity. After investigation and analysis, the chief engineer may recommend that a variance to board rules in regards to the minimum spillway capacity be granted or denied. That then leads to a hearing regarding the variance, and following the hearing, the board may grant the variance upon finding that failure of the dam due to inadequate spillway capacity will not increase the potential for damage from flooding to downstream residents or property. Located on page 7 of the staff report, figure 2 shows the depth velocity flood danger relationship for houses built on foundations. It is color coded in indicating low risk to occupants of houses up to high risk in relation to increasing depth and velocity of a flood event. Table 4 on page 10 of the staff report compares the risks to downstream structures with the dam failing at the 23% PMF event, that's current capacity, and the risks to downstream structures with no failure if the dam was modified to be able to pass the 50% PMF event. This information indicates that at the current level of downstream development, there is a case for a variance to allow the current spillway capacity to be maintained, since requiring the spillway to be upgraded to meet the rule would cause increased risk of damage to downstream residents even without a dam failure. The location of those structures listed on table 4 is shown in the first set of maps of Appendix A of the Houston Engineering Report. Acting Chief Engineer Mathewitz recommends the board granting the variance with qualifications. An overview of the qualifications are, number 1, the standard qualification that even if the variance is issued, the dam still needs to comply with state dam safety rules. Number 2, that the emergency preparedness for the dam be updated annually, and that emergency plan is required to include details of how and when to warn residents and businesses that are most at risk for loss of life from a dam failure should an emergency event occur at the dam. Qualification 3 was making the dam owner responsible for ensuring that a tabletop exercise of the emergency plan be held at least every 6 years. And 4 was to allow for the variance to be reviewed. Basically, so if additional development should occur below the dam in the inundation area that would change the risk associated with allowing this variance, would give the chief engineer an opportunity to bring that variance back before the board. And with that, I will stand by for questions from the board. And I believe we have the city on as well.
Questions from any board members?
Mr. Chairman, so you mentioned the last point, number 4, that you could come back for review from the board. What would trigger that, and how often would that happen, do you think?
What would trigger that would be So we inspect this dam currently every 3 years. So as part of that inspection, we would look at the downstream area, basically load up the inundation mapping and see if there'd been new development that would potentially change the risk of allowing this variance in terms of loss of life to the downstream area. If we do see new development, we would obviously dig further, go back and look at these depth velocity relationships to see if upgrading the spillway would reduce risk to that new development. And if we did find that continuing to allow the current capacity would cause a greater danger to any new development downstream, that would be when we would bring it back. Did that satisfy your question?
Yes, thank you, Mr. Chairman.
Any additional questions from the board? Hearing none, do I have a motion to adopt the chief engineer's recommendations to grant the city of Mitchell's petition for a variance from minimum spillway design requirements for Lake Mitchell?
This is Comus, so moved.
Thank you, Mr. Comus. Do I hear a second?
Freeman, second.
Thank you, Mr. Freeman. All in favor of the granting of this petition and following the chief engineer's recommendations, please say aye. Aye. All opposed?
Aye.
All opposed, say nay. Hearing none, the petition and recommendation of the chief engineer is adopted. The next item on the agenda is to consider the water permit application number 8987-3 with Vic Utech. Thank you, you may proceed. Oh, yeah, I need to know appearances, sorry.
Stacy Hagee and Marcus Lucky appearing on behalf of the applicant Victor Utech, who is also personally present.
Any other appearances?
Emily Greco, on behalf of the chief engineer in the water rates program.
And James Moore on behalf of the Spring Creek, Cow Creek Sanitary District, the petitioner in this case, and Todd Schneider, who's a member and vice president of the Board of Trustees, is with me today.
Thank you. You may proceed.
Mr. Chairman, I would first like to request a ruling from this board on a matter dispositive to the hearing today. The applicant moves to dismiss the Spring Creek, Cow Creek Sanitary District and its opposition to the water permit application because the sanitary district has no standing to proceed given the scope of its opposition and because its challenge will otherwise fail as a matter of law. This board's review is limited to the 4 prongs in relation to granting a permit to appropriate water. This board is to consider whether there is reasonable probability that unappropriated water is available for the applicant's proposed use. Second is the proposed diversion can be developed without unlawful impairment of existing domestic water uses and water rights. Third is the proposed use is a beneficial use. And fourth is that the permit is in the public interest as it pertains to matters of public interest within the regulatory authority of the Water Management Board as defined by SDCL 46-2-9 and 46-2-11. It appears the petitioner is primarily focused on challenging, opposing the petition regarding the public interest factor in this test. The petitioner claims that under the 4th prong, this board should not only consider local ordinances and resolutions in the issuance of its water permits, but it is actually required to consider all local ordinances and resolutions and accounting for those local laws regulating water distribution. And it sets forth that position as requirement for this board and as follows the water rights program in its reply brief submitted just yesterday. The sanitary district intends to offer 25 exhibits encompassing ordinances, resolutions, and various other documents, seemingly to have a trial as to whether Mr. Utech is required by those sanitary district ordinances and resolutions to hook up to the sanitary district system, with this board serving as the judge. However, as a matter of law, the sanitary district laws and rules and regulations are not within the scope of this board's regulatory authority. this, the provision regarding limiting the public interest prong to the matters that are within the regulatory authority of this board was recently added, I believe, in 2021, and really to avoid the situation that the board is faced here with today. There was a contested case hearing that took up a number of hours, days, and petitioners came in and raised concerns with all things that were actually outside the scope of this board's regulatory authority. So, Water Rights Program proposes legislation to ensure that these hearings are simply limited to what this board has regulatory authority over. This board cannot implement or take enforcement action under the sanitary district ordinances, and it should not be adjudicating the rights of these two parties under those ordinances. In its attempt to stretch this board's regulatory authority to include that, the petitioner references a number of cases from all different aspects to try to tie everything together. But none of those stand for the proposition that this board has jurisdiction to hear evidence and adjudicate a water permit applicant's obligations under another governmental subdivision's laws. Instead, the South Dakota Supreme Court case that I've cited in my pre-hearing brief regarding the solid waste disposal permit application by the city of Sioux Falls is on point. That case analyzed the limited scope of the board's authority, and as the Supreme Court upheld in that case, the board's jurisdiction was limited and not to be considered matters of local concern. There's a forum for those local concerns, but it is not here before this board. I do want to point out, and I believe the board, or the district will acknowledge, that there's a federal court proceeding between Mr. Utecht and the sanitary district, with the federal court addressing whether Mr. Utecht is required to hook up to the sanitary district system. In that case, the party's claims will be ruled upon by the federal judge, including whether he has to hook up his RV park to the private water system or to the sanitary district system pursuant to those sanitary district ordinances. Whether the resolution that the sanitary district has enacted, which requires everyone in its district to hook up, may trump its own ordinance that allows everyone outside of 400 feet of a water main to use their own private system. Whether the ordinances and resolutions themselves are valid and constitutional. In the solid waste disposal case, the petitioners had made an argument that the board proceedings should be stayed as it pursued separate litigation, and ultimately until there was a decision on that separate litigation before ruling upon the permit at issue before the board. But I would emphasize that I only point out the federal case to emphasize that this hearing that's proposed today is already being pursued in federal court. I don't want to indicate that I don't want to invite this board to pause this proceeding while that separate litigation is going on, because again, Mr. Utecht's obligations under that sanitary district ordinances and rules are not contingent upon this board's authority and the issue of this permit application. In going back to the Supreme Court case of the solid waste disposal case, they had made the argument to stay the board proceeding. The Supreme Court upheld the board's decision to reject that argument. And the Supreme Court said that they find no merit or support for that argument itself. Frankly, I'm not aware of any other matter before this board in which this board has heard evidence and adjudicated a water permit applicant's obligations to another governmental entity when determining whether to issue the water appropriation permit. As acknowledged in the petitioner's opening brief, the South Dakota Department of Agricultural and Natural Resources did not take a position on this issue when issuing its approvals, and I respectfully request this board to do the same. A conclusion that the board is required to consider another entity's local ordinances and resolutions as part of the public interest prong would not only impose inappropriate burdens upon this board, but also on the Water Rights Program chief engineer and its staff to analyze and make legal determinations relating to all other local ordinances or laws when analyzing these permit applications and issuing its recommendations. Further, if the board were to adopt the petitioner's petition and consider evidence and testimony today, the board is effectively ceding its authority to another governmental entity. In effect, the sanitary district seeks a decision by this board that this board cannot issue a water rights permit within the sanitary district boundaries because of a sanitary district resolution that requires everyone within the boundaries to hook up to its own system. Such decision is directly contrary to the legislature's establishment of the Water Management Board and Water Rights Program, if other entities can dictate this board's own authority. Ultimately, the petitioner has failed to articulate how this board has regulatory authority over a sanitary district's ordinances and resolutions. Petitioner has made no challenge that actually falls within this board's jurisdiction, and accordingly, I respectfully request this board to deny the petition as a matter of law. Thank you.
Mr. Moore?
Thank you, Mr. Chairman. A standing argument is a polite legal way of saying that the sanitary district has no right to be here before the Water Management Board to contest this particular permit application. And our position is that as a legal proposition, that's simply incorrect. It's also hard to understand the logic and the common sense of that position, given the history between the parties here related to the development of the campground that's at issue and providing water to the and sewer service to that campground. It's inconsistent with previous efforts by Mr. Utek to exclude that development from the sanitary district altogether, and there'll be evidence presented on that today. It's inconsistent with the sanitary district's clear interest in enforcing its ordinances, which require that members of the sanitary district obtain sewer and water service from the district. It's inconsistent with the financial burdens imposed on the district to develop infrastructure to serve this development, and inconsistent with the financial burdens created for the district if this development is allowed to be excluded from the district, in effect by appropriating water from a different source to serve its own private sanitary sewer system. With respect to the legal argument, under SDCL section 46-2A-3, the two issues that have been raised in the motion are whether the district has suffered an injury unique from any injury suffered by the public in general, and whether the injury concerns a matter within the regulatory authority of the board. With respect to the first factor about a unique and distinct injury from the general public, first, the district needs to enforce its ordinances and resolutions. It is appropriate for the district to do that, and it's appropriate for the district to appear before this board to do that, given the public interest factor that is part of the burden of proof that this board has to consider in deciding the permit application. And with respect to the need to enforce its ordinances, the law doesn't mean anything if it's not enforced. And the district has an ordinance that says that all residents need to hook up to the district's water and sewer services, and if it can't enforce that ordinance, then it's meaningless. The request that is before this board to consider the district's ordinance, which by statute it has the authority to enact, is really no different than asking this board to consider state statute in deciding whether something is within or not the public interest. And as indicated in the brief that we submitted, the public interest is in fact defined by legislative acts, whether they be by the state legislature, by municipal governments, or in this case by the sanitary district, a governmental entity in a political subdivision of the state of South Dakota. Second, with respect to the distinct injury, the district has an injury to its pocketbook. It has planned for this development. It has obtained loans from the state of South Dakota that it is financially obligated to repay. It has covenants in those documents that require it not to allow any competition by private systems within the district. And that's expressly meant so that it has the financial ability to repay the obligation that it got from the state. So it clearly has an interest in enforcing its ordinances and in protecting its pocketbook that is separate and distinct from any injury to the general public. And lastly, with respect to that factor, if Mr. Utek's argument is correct, then essentially no public entity would be able to appear before this board because it's always asserting the rights to some extent of its members, of its residents, of its citizens. That's necessarily the case, but when you take a step back and when you look at the distinct interests that the sanitary district is here to uphold today and to assert today, they're clearly sufficient to meet that first statutory prong for standing. The second issue is whether the issue is within the regulatory authority of the board. The petition concerns the use of water, and the district's injury is within this board's authority because it concerns the use of water. I'm familiar with the change in the law that occurred. I was here representing Keystone XL Pipeline. I think we had an 11 or 12-day hearing before this board, and we talked about work camps, and we talked about sex traffic, and we talked about all kinds of things that were not related to water. That's not what we're doing today. We're here to talk about the sanitary district's provision of water and sewer services to members of the district and a permit that would allow a member of the district to circumvent the obligation of the residents of the district to obtain water and sewer services from the sanitary district. So this is clearly different than what was contemplated by the change in the law and the reason that the law was changed. And the issue of water use is clearly within this board's authority. It fits clearly within the general supervision of the waters of the state. And it's also within the public interest and beneficial use factors, again, in the standard of proof under SDCL 46-2A-9. And I know that issue goes to the merits that is before the board, but I don't think that you can ultimately decide the standing argument that has been placed front and center without recognizing that public interest factor as part of the standard is in fact relevant to the motion to dismiss. With respect to the fact that there is a federal lawsuit pending, there are in fact 2 lawsuits pending in federal court brought by Mr. Utek and various limited liability companies that he is a member of against the sanitary district. They concern different technical issues that are not before this board today. They may or may not be resolved in federal court. They are in the early stages of litigation. Different counsel represent the parties in both of those cases in federal court. I would simply submit that there's no basis for this board to abstain from deciding a matter that is directly before you because of the federal cases that are pending. So in a nutshell, I think that the standing argument is a bit of a Hail Mary. It's a way to avoid deciding the merits of the arguments that the sanitary district has raised and that the sanitary district asks your consideration of today. There are important issues to the sanitary district. They concern the use of water. They're within the scope of this board's authority, and that's why we're here today. So I respectfully request that the motion to dismiss based on standing be denied. Thank you.
I would mirror much of what was said by the counsel for the applicant. The board does not have the regulatory authority to decide matters of the district's ordinances. The proper venue for that would be in front of a court. The board is tasked with determining whether there is water available for the permit as outlined in SDCL 46-2A-9. As you're familiar, those factors are the reasonable probability that unappropriated water is available. The proposed diversion can be developed without unlawful impairment of existing domestic water uses and water rights. The proposed use is a beneficial use and the permit is in the public interest. Much of the district's arguments revolve around the public interest argument. The district misconstrues this element to mean that if members of the public would be against an appropriation, then the public interest element is not met. That's not necessarily true. If it was determined that every time a member of the public or members of the public were not in favor of a permit, the board would have to deny every permit. Additionally, public interest takes into account a broader societal goal, not a localized concern such as ordinances that would prohibit individuals hooking up to water. SDCL 4612 says, it is hereby declared that the protection of the public interest in the development, it is hereby declared that the protection of the public interest in the development of water resources of the state is vital concern to the people of the state, and that the state shall determine in what way the water of the state shall be used. Then 4614 says, it is hereby declared that because of conditions prevailing in the state, the general welfare requires that the water resources of the state be put to beneficial use to the fullest extent to which they are capable. Appropriating water for a commercial use has historically been seen as a beneficial use and in the public interest by this board. And appropriating water for a commercial RV park that supports recreation enjoyed by the broader population of the state should certainly be seen as within the public interest.
Thank you. At this time, I'm going to make a motion pursuant to STCL 1-25-2, subparagraph 3, to enter into executive session for the purpose of consulting with legal counsel regarding proposed or pending litigation today. Do I have a second to my motion?
Second, Freeman.
All in favor, say aye.
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 All opposed, say nay. Hearing none, at this time we'll go into executive session.
We're gonna go, you guys can stay.
We're gonna go, you guys stay.
Leo, you're gonna have to drop off this call. I'll call you on my phone. I'll leave my phone in the room with the board, so I will call you in a couple minutes, okay?
Okay.
All right.
Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net. Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net. Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net. Thank you for listening to the South Dakota Network, a service of SDPB. Links to live events and their archives are available at sd.net. Thank you for listening to the South Dakota Network, a service of SDPB. Links to live events and their archives are available at sd.net. Thank you for listening to the South Dakota Network, a service of SDPB. Links to live events and their archives are available at sd.net. Thank you for listening to the South Dakota Network, a service of SDPB. Links to live events and their archives are available at sd.net.
Okay, at this time, we're gonna call the, Water Management Board, meeting back into order. At this time, I'm gonna make a motion to deny the motion to dismiss, the intervening petition. Do I hear have a second?
Second.
Thank you, Mr. Freeman. I'd like a roll call on that matter, please.
Thomas.
Aye.
Dixon. Aye. Freeman.
Aye.
Heffler.
Aye.
Goldbauer.
Aye.
Larson.
Aye. This time we'll take evidence from the state first, department.
I think I'll start by moving to admit Exhibit 1, which is the administrative record, into the record. I'd call Engineer Austin Secchi.
For the record, I don't object to.
So admitted.
Mr. Moore, do you have any
We
objections?
have no objection to the admission of Exhibit 1.
Can you state and spell your name for the record?
Austin Secchi, AUSTIN SETTJE.
No, you guys want to? I'm going to show you what's been marked as Exhibit 2. Can you tell me what that is?
This is my curriculum vitae.
And did you make that document?
Yes, I did.
Is it up to date?
Yes, it is.
At this point, are there any changes you would make?
No.
I move to admit Exhibit 2.
No objection.
No objection.
Exhibit 2 is admitted.
Thank you.
Can you describe your educational background for the board?
I have a Bachelor's of Science in Industrial Engineering and Engineering Management from the South Dakota School of Mines and Technology.
And how are you currently employed?
I am a resource engineer for the Water Rights Program.
How long have you been with the Water Rights Program?
Approximately 2 years.
What do you do for the Water Rights Program?
I prepare technical reports for the chief engineer. I help review observation well data and take observation well measurements. And I also inspect safety for dams.
When you do those technical reviews, are those typically for groundwater or surface water?
Groundwater.
And are those reviews then reviewed by somebody else?
Yes.
How many people typically peer review your reports?
6.
And peer review is the typical practice of the Water Rights Program?
Yes.
Are you familiar with water permit application number 8987-3 for applicant Victor Utek?
Yes.
Can you describe for the board what this application proposes to do?
Water permit application number 8987-3 proposes to appropriate up to 2.45 acre-feet of water annually at a maximum pump rate of 0.22 cubic feet of water per second from one existing well completed into the Grey Goose Aquifer. The well, located in the northwest quarter, southeast quarter, Section 34, will supply water for commercial use at an RV park to be located in the southeast quarter, Section 34, all in Township 113 North, Range 80 West. This site is located in Sully County, approximately 12 miles northwest of Pierce, South Dakota. Additionally, this application, if approved, uses the same well that is currently authorized under water right number 8008-3, authorizing irrigation of 131 acres. The proposed appropriation of up to 2.45 acre-feet of water annually at a maximum pump rate of 0.22 CFS would be in addition to the 2.22 CFS authorized by number 8008-3. Combined, water right number 8008-3 and water permit application number 8987-3 will appropriate groundwater at a maximum combined diversion rate of 2.44 CFS from one existing well completed into the Grey Goose Aquifer.
And just to clarify, application number 8987-3 is a new permit, and it's separate from water right number 8008-3.
Water permit application number 8987-3 is a new permit.
Can you describe the hydrology of the Grey Goose Aquifer?
The Grey Goose Aquifer is a buried outwash deposit of coarse sand and gravel that partially fills a broad, irregular river channel that was carved in shale bedrock. The Grey Goose Aquifer extends approximately 30 miles from the northwestern corner to the central portion of Hughes County. Additionally, the Grey Goose Aquifer extends a few miles north into the southwestern portion of Sully County, where this application is located. For the Grey Goose Aquifer, Hedges and others estimated that the Grey Goose Aquifer underlies 33,400 acres, approximately 52 square feet, and contains approximately 200,400 acre-feet of recoverable water in storage. Further studies by Hamilton propose that the Grey Goose Aquifer recovers approximately 120 square miles, or 76,800 acres, and contains approximately 610,000 acre-feet of water in storage. There were multiple well completion reports that were submitted with this application and water right number 8008-3. The range of some of the basic well characteristics in this report show a static water level ranging from 28 feet to 47 feet below the ground surface, a saturated aquifer thickness ranging from 23 to 43 feet, and a well depth ranging from 51 to 90 feet.
And then, can you now summarize for the board your findings on the availability of water?
We look at recharge and discharge as well as observation wells. For recharge, the Grey Goose Aquifer is mostly by infiltration, precipitation, and inflows from Lake Oahe when the water level in the lake is higher than the potentiometric surface of the aquifer. The Grey Goose Aquifer is both confined and confined in portions, which gives it a variable spread of range. Overall, the average annual recharge to the Grey Goose Aquifer likely lies between the range of 1,670 to 8,907 acre-feet per year. This range is based on Hedges and others' recharge rates of unconfined and confined portions of the Grey Goose Aquifer and the estimated aerial extent of the Grey Goose Aquifer. Also, this range is likely influenced by the hydrological connection of the aquifer to Lake Oahe. At the time of writing this report, there are 23 water rights permits authorized to appropriate water from the Grey Goose Aquifer. Of those, at the time, 4 are non-irrigation water rights authorized to appropriate water from the Grey Goose Aquifer, and at the time of writing the report, there are also 19 irrigation water rights permits authorized to appropriate water from the Grey Goose Aquifer.
Did you also look at observation wells?
Yes.
Can you describe for the board what you looked at when you looked at the observation wells?
The Danner Water Rights Program monitors 9 observation wells completed into the Grey Goose Aquifer. We look at all the observation wells within the Grey Goose Aquifer, but primarily for this report, we look at the 3 closest observation wells that to the well the applicant proposed to use, which are as follows: HU-2018A, which is approximately 1 mile southwest, HU-80A, which is approximately 2.7 miles southeast, and HU-80B, which is approximately 4.6 miles southeast. It should be noted that HU 2018A has a limited period of record and does not provide a full assessment of the aquifer's performance over an extended period of time. Additionally, HU 2018A also lies in close proximity to the Wahi Reservoir and is more than likely influenced by the changes in the reservoir. The hydrographs for the observation wells display stable to rising water levels over their respective periods, and the hydrographs for the Grey Goose Aquifer indicate that the aquifer responds well to climatic conditions because water levels are rising during wetter periods and declining to a stable water level during drier periods. Additionally, the water levels in the observation wells display that the amount of recharge to and the natural discharge from the aquifer greatly exceed pumping.
Can you now describe for the board your findings on the potential for unlawful impairment?
Looking at unlawful impairment, we look at the closest water rights permits, domestic wells, and also complaints that have been filed for adequate wells within the Grey Goose Aquifer. The closest water right permit not held by the applicant to the proposed diversion point is water permit number 6732-3, which is held by Oahe Speedway LLC. The proposed diversion point for water permit number 6732-3 is located approximately 0.23 miles north of the proposed diversion point for this application. Additionally, the closest domestic well on file, not held by the applicant, is located approximately 0.5 miles west of the proposed diversion point. In the area around this water application is generally shows unconfined conditions. Based on the well completion report submitted with water right number 8008-3 and this application, there is expected to be at least 43 feet of saturated aquifer at the time of drilling. Any drawdown as a result of the diversion for this application is not expected to unlawfully impair nearby adequate wells. In Hughes and Sully County, there are no complaints on file with the Danner Water Rights Program regarding well interference for adequate wells completed into the Grey Goose Aquifer.
Overall, what did you conclude in your report?
Based on the observation well data and the hydrologic budget, there is reasonable probability that unappropriated water is available from the Grey Goose Aquifer to supply the proposed appropriation. And there is reasonable probability that the diversion by water permit application number 8987-3 will not unlawfully impair adequate wells for existing water rights permits holders or domestic users with adequate wells.
I have nothing further.
Cross-exam.
Setchi, I believe you mentioned that there are areas of both confined and unconfined in the aquifer, correct?
Yes.
Could you please tell me whether the specific location of the existing well is confined or unconfined?
Unconfined.
And the total estimated recharge for unconfined is 8,907 acre feet per year. That was your conclusion, correct?
Yes.
You talked about about water rights completed into the Grey Goose Aquifer, there are no future use permits, correct?
No.
Do you know when the last time was that someone has applied for a water rights permit from this aquifer?
I do not.
Would it be in your report?
Of the last one that was completed into the Grey Goose?
The last, yes.
No, I don't think so.
Do you have your report in front of you?
I do.
Okay.
It may.
So on page 7, which you agree, it looks like there's been 19 permits since 2023.
In both 2023 and 2024, there were 19 irrigation reports that have to submit irrigation.
And there remains 19, correct?
Yes, from 2023 to 2024, it remained 19.
And then today, currently, there's 19 permits, correct?
Yes, I am unsure.
And so your conclusion, well, let's see, you've calculated an estimate for the total withdrawals annually, correct? On page 8 of your report?
Yes, in page, the estimated average annual withdrawal rate from the Grey Goose is approximately 1,887, and that is a combination of non-irrigation, irrigation, and this application, if approved, assuming full volume.
And so based on your review of all of that information, you conclude that there's a reasonable probability of availability of unappropriated water.
Yes.
You mentioned the Owyhee Speedway water right. Was there any information that you reviewed that caused you to question whether the permit would be subject to cancellation?
I think it is subject to partial cancellation.
And can you describe that for me, please?
I don't know if I can recall the specifics right now.
So when could something be subject to partial cancellation?
It would depend on the specific instance, but they would maybe not meet requirements met by the state.
So that could make that permit fall off or be adjusted
Yeah.
for the aquifer, correct?
Yes.
Okay. I don't have any further questions for you, Mr. Secchi.
Okay, thank you.
Mr. Moore?
Thank you, Mr. Chairman. Mr. Secchi, the conclusions in your report to the chief engineer are on page 13, correct?
Yes.
And conclusion 2 is about the reasonable probability that unappropriated water is available, correct?
Yes.
And the third conclusion is that there's not likely to be any unlawful impairment of existing wells and water rights, correct?
Yes.
And your conclusions did not specifically address the public interest and beneficial use factors that are included in the statute governing the application in this case. Is that correct?
Could you rephrase that question?
Sure. There's no discussion in your report to the chief engineer of the beneficial use and public interest factors in the statute. Is that correct?
My report revolves around doing the technical aspect of the report.
Correct.
Yeah.
So you did not consider the effect of the permit being granted on the Spring Creek, Cow Creek Sanitary District, right?
Correct.
That's all I have. Thank you.
Okay.
Additional testimony or questioning?
I have nothing further.
Additional witnesses to present?
Yes.
Does the board have any questions? Now do you have additional evidence?
Yes, I would call Adam Mathewitz. Can you state and spell your name for the record?
Adam Mathowitz, Mathiowetz.
And now I'll show you what's been marked as Exhibit 3. Can you tell me what that is?
That is my curriculum vitae.
And did you produce that document?
Yes, I did.
And is it up to date as of today?
It is up to date as of April 26th, the updated date on the bottom of the document, but it is also updated today.
Are there any changes you would make?
No.
All right, I move to admit Exhibit 3.
No objection.
No objection.
Exhibit 3 is admitted.
Adam, can you describe your educational background?
I hold a bachelor's and master's of science in agricultural and biosystems engineering from South Dakota State University.
And do you have any professional licenses?
I am a licensed professional engineer in the state of South Dakota.
What is your current position with the department?
Currently, I am the acting chief engineer of the Water Rights Program.
How long have you been in this position?
3 months,
And how long have you been with the Water Rights Program?
14 years.
What did you do before you were chief engineer?
I was a technical engineer, going from engineer 1 through up to engineer 4. During that time, I was a groundwater specialist, focusing on well construction, our observation well network, including management and data analysis, reviewed water completion reports, as well as provided technical analysis on water permit applications.
What do you do now as the chief engineer?
Now I serve as the administrator of the program, sort of under direct rule of Office of Water Division Director Mark Mayer. I am the administrator of the State Dam Safety Program. I am responsible for managing the day-to-day tasks of ensuring applications are assigned and reviewed for technical report, as well as ensuring all other rules that we have are followed, and then also serving as technical guidance to the Water Management Board, other state and federal agencies, and the general public.
Can you tell the board now about how a water permit application moves through the process?
In short, the Water Rights Program receives an application. We ensure it's complete. If not, we return it to the applicant to complete it. And then upon having a completed application, that application is assigned to a technical engineer after we determine water source to review for the availability of unappropriated water, as well as the potential for unlawful impairment of existing water rights as related to that particular application. Then that report is reviewed by technical staff as a peer review and corrected as such and updated. Then that updated report is given to the admin staff, including myself, for another review. Again, technical as well as administratively, looking for any issues with laws or incorrect analyses. And from there, the finalized report allows the chief engineer to make a recommendation. That recommendation is noticed in newspapers as well as on the department website. The public notice is done in the paper of record for the county where the application is. If that newspaper is not a daily newspaper, it is also noticed in the nearest daily newspaper. That notice allows time for intervention and comments from the public as well as the applicant if that recommendation is something the applicant does not agree with. If there are no petitions or issues against that, that would create it to come to the board, such as a deferral recommendation would automatically come to the board hearing. But let's, if it's an approval recommendation and there are no petitions against it, then we can administratively approve it for the board. Otherwise, it comes to the board for hearing and their decision.
And are you familiar with application number 8987-3?
Yes, I am.
Briefly, what is this application proposing?
This application is proposing a new appropriation of water to serve as a commercial use in an RV park.
What was your involvement with this application?
Originally, I was still the technical engineer at that point, so I did the initial review of the application to determine water source and assign it to a staff engineer to write the technical review. Then I also did I'm involved in that writing process as they have questions as they proceed. Then I do a peer review as the technical staff, as an engineer, and then I do a look through of any notes from the administrative staff to make sure no technical information was accidentally changed with phrasing.
Do you agree with the recommendation of the previous acting chief engineer, Mark Mayer?
Yes, I do.
What is that recommendation?
That recommendation is approval with qualifications.
Can you tell the board generally what those qualifications are?
There were two qualifications on that recommendation. One is the standard well interference qualification that is on all groundwater permits and recommendations, is acknowledgement that the well the applicant intends to use is located near domestic wells and other wells that obtain water from the same aquifer, and that the well owner is responsible to maintain and control their withdrawals such that there's not a reduction of needed water supplies, inadequate domestic wells, or inadequate wells having prior water rights. The second qualification on the recommendation for this was the permit holder must report to the chief engineer annually the amount of water withdrawn from the Grey Goose aquifer.
Can you tell the board how this permit would be in the public interest within the regulatory authority of the board?
As required by state statute, water in our state is to be put to the maximum beneficial use capable, while also maintaining consideration for the recharge and withdrawals to the aquifer to maintain our water as we go into the future. A commercial use for an RV park has been historically considered by both the Water Management Board and the Water Rights Program as a beneficial use in the public interest to place that water to use.
And now, how would this application be a beneficial use?
Again, placing the water to use for business purposes in a commercial operation of an RV park is a beneficial use of water.
Did you review the petitions in this case?
Yes, I did.
One of the concerns in the petitions was involving a district ordinance. How would you respond to that concern?
The district ordinance does not affect the recommendation because just having the water right does not guarantee you access to the well. You may need to, and therefore other applicable laws may require you to do other things beyond just obtaining the water right.
And then another concern in the original petition concerned amending an irrigation permit and converting it to a permit for domestic or commercial use. How would you respond to that concern in the petition?
This is an application for new use that happens to be using an existing well that was originally authorized for irrigation use.
Are wells use specific?
No, an individual well is not typically use specific.
After reviewing these petitions, are you at all concerned about your recommendation?
No, the recommendation of the previous chief engineer and my agreeance with it stands.
I have no further questions.
Ms. Heggie?
Yes, thank you. Mr. Mathewitz, now, I understand that the chief engineer makes the recommendation on approval of the application, correct?
Correct.
And so, and that application can then be approved if there's no objection to it.
If there, during the public notice period, no petition to intervene, the application can be administratively approved under statute and administrative rule.
So that effectively requires you to make a determination on all four factors in relation to the water appropriation permits, correct?
Correct.
In the consideration of the public interests under the board's regulatory authority, have you or your office ever looked at other local ordinances to determine whether there's other water sources available?
Could you rephrase the question, please?
In determining what is in the public interest under this board's regulatory authority, what do you consider?
In determining public interest, we consider past practice of both the Water Management Board and the Water Rights Program, as well as statutes and rules that are within the purview of the program and the Water Management Board.
No further questions.
Mr. Moore?
Thank you, Mr. Chairman. Mr. Mathewitz, at the time of the recommendation that is part of the administrative record in this case, the chief engineer did not consider the public interest issues that are advanced by the petitioner of the sanitary district in this case. Those issues had not been raised yet, correct?
At the time of the recommendation, I am not aware of any issues that the sanitary district has currently raised that if they were raised to then acting chief engineer.
And I think you testified in response to a question from Ms. Greco that other applicable laws may apply, and in your review, the chief engineer is simply not taking a position with how that plays out in terms of the public interest. Did I understand that correctly?
The external laws outside of the purview of the Water Management Board and the Water Rights Program, as particularly those that we may or may not be aware of, are generally not considered as part of the public interest.
So, am I understanding your testimony correct that you think that the Water Management Board should not consider the interests of the sanitary district as part of the public interest analysis under the applicable statute here?
I cannot speak for the Water Management Board and what they should or should not consider.
So, so as the chief engineer speaking on behalf of water rights, you are not taking a position on that issue, is that correct?
Please restate the question again to make sure I understood it fully.
Sure, just based on your answer, it seems to me that what you said is you're not speaking on behalf of the Water Management Board. My question is whether you're taking a position before the board with respect to the question whether the sanitary district's interests in this matter are relevant to the public interest determination.
Based on the petition from the sanitary district, which is in regard to ordinances specifically, I am not taking a position on whether that is considered within the public interest, because that is not within the purview of the rules that I am charged to work under.
Thank you. That's all I have.
Yes or no questions?
I don't have any.
Any questions from the board?
I have a couple questions, Mr. Chairman. Is amending from an irrigation to a commercial, is that typically an administrative function, or do those typically come before the board, or how do you usually treat those?
Under statute, you cannot amend an irrigation application to a commercial use. I don't have an intimate familiarity with the laws because of the newness of my position. I do believe there is some allowance to convert to municipal use, as has been done historically with some Rapid Creek. That also might be unique to Rapid Creek due to its extensive history. But I know for commercial use such as this, it has to be a new application. You cannot amend the irrigation permit.
Okay. One more. Does the Water Rights Program ever withhold an application which has not been sought to be intervened? Do you ever withhold approval of those due to the public interest issue and send it to the board? Or is it basically if there's no intervention, it's automatically approved? Is that correct?
There have been cases in the past that we have done what is called a long form notice, which is as part of the notice process, we automatically notice it for hearing. Some of them is whether it is a well-known and largely what we believe to be a contested case, as just let's get it scheduled. I do believe there have been, by several of my predecessors, some occasions where beneficial use or public interest has been considered, but I don't know if those were approval recommendations off the top of my head.
Okay, thank you.
Any additional questions from the board? Maybe excuse sir. Any additional evidence from the state?
No.
Ms. Hagee, are you ready to proceed with your
Yes, I am,
evidence?
Mr. Chairman. I do want to make sure where we're at on exhibits, have 1, 2, and 3 all been admitted, correct?
Yes.
Okay. Mr. Chairman, I would call Mr. Victor Utek.
Mr. Utek, will you take a stand, please?
Raise your right hand, please. You solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
If I could please have you state your name for the record.
Victor Utek.
And Mr. Utek, where do you reside?
I reside at 428 Anchor Down Avenue, Pierre, South Dakota.
Is that within city limits of Pierre?
No.
What do you do for a living?
I operate a RV park. I have a tree farm. I have a golf course. And I farm.
You also, do you act as a developer too?
Yes.
How long have you been developing property?
35 years.
And we're here today regarding your water rights permit application for an existing well in Salt Lake County, correct?
Correct.
Now let's talk about the general location of the property involved in this application. This is in Salt Lake County.
Correct.
And I have an exhibit here for you that's marked Exhibit 103, and actually I'll do Exhibit 104 as well, that I'll hand you.
Any objection?
No objection to either 103 or 104.
No objection.
Exhibits 103 and 104 admitted into evidence.
For the existing well that we're here talking about today, is that located in an area commonly referred to as Spring Creek, Cow Creek community?
Yes.
And Exhibit 103, is that a pretty good map of the area where the well is?
Yes.
Now, on the west side of that map, there's a highway 1804, I believe, correct?
East side.
East side, yep, sorry, east side. And the existing well is just west of that highway.
Correct.
Is this area, is it an incorporated municipality?
No.
Describe the community attractions and businesses in the Spring Creek, Cow Creek community.
So basically, this peninsula is a recreational peninsula. Quite frankly, if it wasn't for the lake, it'd probably be cows and corn. But, you know, it's been promoted by the state as well as other individuals, including myself, that for recreation, you know, we have
restaurants, state boat ramps, state parks, private parks, those types of things.
You have a golf course, I think you're getting ready to open in that area, correct?
Correct.
And you mentioned state parks, that would be Cow Creek State Park and Spring Creek.
Yep, state, those are both state parks, yes.
And are those on, if you turn the page to Exhibit 104, are those two state parks demonstrated on Exhibit 104?
Yes, they are.
Now, you mentioned it was the summertime activities. Could you please describe the makeup of the area in regards to full-time versus seasonal residents?
It's pretty vibrant, basically, in the summertime. A lot of people coming and going. I would probably generally say that there's a lot of activity, and considerably just the opposite in the wintertime. Of course, there's no recreation to speak of, and I believe it's somewhere between 75 and 80% of our full-time population is probably gone.
And you mentioned you have an RV park in this area, correct?
That's correct.
Okay. What's the name of that RV park?
Codgers Cove RV Park,
How many RV spots are in Codgers Cove?
275,
Are those routinely filled every summer?
always.
So now let's go back to the property in which this existing well is placed. When did you purchase this property?
October 18th, I believe, of 2020.
And who did you purchase it from?
Cow Creek Recreation.
Was there any commercial operation on that property when you purchased it?
Yes,
What was that?
there was the Oahe Speedway, and there was an associated RV park to go along with the Speedway.
So after you purchased the property, at some point, did you decide to pursue expanding and redeveloping the RV park sites?
Yes,
And what is the name that you've given to that RV park?
Codgers Castaway RV Park.
So as you're going through this process of revamping the RV park, did you learn anything in relation to the existing well on the property?
There are two existing wells on the property that I purchased, and there's water lines from those wells throughout this entire property that provided water in the past to everything in this area, including the RV park and the racetrack.
How was the well classified?
It was classified, under my understanding, like I said, I purchased it, but I believe it was classified through the DANR as an irrigation well.
And did you have any discussions with the South Dakota Department of Agricultural and Natural Resources regarding the appropriate steps to address the classification of the type of well?
Many.
After having those discussions, what steps did you take?
So following the instructions of Amanda Duell, Barb, lost her last name right now. And then Aaron Fagnan and Mark McIntyre, I went through the process of changing the well from irrigation to a domestic use or commercial use.
And you submitted an application then to the department, correct?
I did.
Did you have any assistance in completing the application?
Yes, the four people I just mentioned, along with my engineer, Jason Smith.
And your intent was to use this well then for the RV park that you planned?
Correct.
When you initially submitted the application, did you identify the amount of water that you were seeking to appropriate?
Originally?
Yes.
Yeah, originally I submitted that I thought that 35 gallons a minute would be sufficient coming from the well.
Why did you think that was sufficient?
I just going off of, past usage of the other RV parks in the area.
Did you have any discussions with the department about that number that you included?
Yes, matter of fact, we had, I believe Zoom meetings or conference calls with the 4 people from the DANR that I previously just mentioned and my engineer. And they felt that that was a little light on the number for the volume, so we agreed to do a 70 gallon per minute volume.
And now your application says you're seeking to appropriate the water for a 213 site RV park, correct?
Correct.
Does that remain your intent at this time?
Yes.
Okay. What is your intended use for the water that you will appropriate from the well if this permit is approved?
So, I mentioned earlier, I got a nursery permit, so I do tree nurseries and stuff. I'm kind of a tree nut, so, and I like grass and everything. So anyway, this water be not only used for the campground itself, but for the maintaining and upkeep of the grass and the trees in the area around it.
Is the use of the water for your proposed RV park beneficial to you?
Yes,
How?
this is how I make my living.
Does anyone else participate in your commercial businesses in the area?
Yes, my entire family. I have a son, I have a daughter, and I have a 3rd generation, a granddaughter, that this is all being built for future generations of my family to come.
How do you believe using the water for a proposed RV park will benefit the general public in that area?
Absolutely.
How?
It brings people in. We've closely worked with the South Dakota Department of Tourism, the Chamber of Commerce and stuff over the years, and to promote the growth of the Spring Creek, Cow Creek area and our business.
By bringing people in, does that provide any financial benefit to the county?
Absolutely. Tax dollars, and as well to the county, yes, tax dollars, sales. These people spend money there at the businesses in the area, without a doubt, quite a bit of money. And they also potentially invest in the future plannings of their family by potentially buying property.
Does it provide an opportunity for more visitors to the 2 state parks that you previously discussed?
Absolutely.
And tell me about lodging, the lodging situation out there.
Quite a bit of lodging. You know, the state offers campgrounds, they offer cabins, and then, you know, obviously there's some private entities there, another campground with cabins, which is Dakota Sky. There's Donnie Ramblers that has RV park and some mobile homes. There's the Outpost, and they provide RV park, bar, restaurant, campsites, those types of things. Of course, we mentioned the state parks. I provide, you know, a state park. You know, I have also a business that I have the Tiki's Bar, which is another business of mine. All those benefit from all this.
So with seasonal businesses, I'm assuming that comes with seasonal employees, correct?
Yeah, almost all of them are seasonal employees. It's pretty empty out there in the wintertime.
Would your proposed RV park provide additional lodging opportunities for seasonal employees in that area?
Yes, we actually have seasonal employees in our RV park now for not only our business, but for other people's business. And we can't provide any more, we just don't have them.
I have no further questions.
Mr. Moore.
Thank you, Mr. Chairman. Mr. Hutak, my name is James Moore. I'm here on behalf of the sanitary district. We've not met before, correct?
Correct, sir.
Nice to meet you.
Nice to meet you too.
Which, if you would look at Exhibit 103, please, I think it would be helpful to me and I hope to the board if we, orient, some of the developments that we're talking about. Your council asked you about, Highway 1804 on the east side of the map shown as Exhibit 103. Do you see that?
Yes, sir.
And could you just describe for the board, please, where the property that you seek to develop as the new RV park to be known as Codger's Castaway RV Park would be located?
Directly north of the intersection of 1804 and the Spring Creek Road, which is, I think, 194 Avenue or Street.
All right, and there's an area there that is sort of has a circular boundary on the right side just to the west of 1804, and it has a series of parallel straight lines that run northwest to southeast. Do you see what I'm referring to?
A circular line?
May I approach the witness and show him what I'm referring to?
Yes, you may.
Just do check on what this area right here.
Okay.
You see that?
Hmm?
Okay, so I'm looking at the area, again, just west of 1804. It's north of the intersection that you referred to, correct?
Correct.
There are a series of parallel lines that run northwest to southeast. You see those?
Correct. Yes, I do.
What is that area?
That is the former racetrack, and all those parallel lines are existing roads from the RV park that's already been there since 2003 or 4.
All right, and is that the property that you want to develop into the new RV park?
Correct.
And when did you purchase that?
It was in October 18th of 2020, I believe.
And what entity actually purchased that property?
Codger's Castaway RV Park LLC.
All right, and can you just describe for the board, please, what Codger's Castaway RV Park LLC is?
That's a business entity owned between my son and myself.
All right, and does it have any purpose other than is its purpose, to develop this property as an RV park? Or does it just own the property?
It owns the property, and its purpose is to expand the usage of that property.
Okay. Ms. Hagee asked you about Codger's Cove. Can you show the board where Codger's Cove is located on Exhibit 103?
Yes, it is on the very east side of the peninsula, at the very end of Highway 1804. It would be directly north of the state Spring Creek Recreation Park.
Since I couldn't see what you were showing.
Oh, I'm sorry. Yep.
All right, you said it was directly, I would say that it's on the west side of Exhibit 103, is that correct?
Yeah, I sit on the west side at the end of the Spring Creek Road and directly north of the state campground.
Okay, and I heard you say east side, so I just wanted to make sure that we're talking about the same place.
West end of the Spring Creek Road.
All right, and do you have another development within the district that is called Codger's Castaway currently?
Yes.
And what is Codger's Castaway?
It is a housing development.
And where is Codger's Castaway located?
On
Exhibit 103.
Should I point again there?
Yes. Please.
Okay, so.
Show the board so they know.
So this is, Codger's Castaway would be approximately right here, about 2/3 of a mile, 3/4 of a mile in from the Highway 1804.
And the area that you're describing is, relatively speaking, directly west of the racetrack property where you want to develop Codger's Castaway RV Park, is that correct?
It is west.
All right, and are there existing platted residential lots that are part of Codger's Castaway development?
Yes,
And are those actually shown on Exhibit 103? In other words, is Exhibit 103 a current aerial photograph?
no,
Okay. How many lots have been developed within Codger's Castaway today?
94.
Object as to relevance.
Overrule.
I'm sorry, did you say 94?
I did.
All right. And are those lots served by, do they get water and sewer through the sanitary district?
Again, object as to relevance.
Overrule.
Oh,
You can answer, sir.
okay. Thanks to get water through me, because that development has not been approved by the sanitary district.
Mr. Utek, when you purchased the property, the former racetrack property to be developed as Codger's Cove RV Park, how many lots did you anticipate developing on that property as part of the RV park?
I believe you said Cove. Did you mean Castaway?
Yeah, I'm sorry, I'm trying to be helpful and I'm making it worse. I'm talking about the racetrack property to be developed as Codger's Cove RV Park. Is that correct?
Cove, no, it's not Codger's Cove RV.
It's Castaway. Codger's Cove is to the west. Codger's Castaway RV Park is the new development, correct?
Yeah,
And how many lots do you propose to develop there?
213.
Mr. Utek, have you been a board member of the Spring Creek, Cow Creek Sanitary District?
Objection beyond the scope of direct and relevance.
I'll sustain that objection.
How long have you lived in the sanitary district?
11 years.
How long have you lived as your current address in the sanitary district?
Since August of 25.
And where did you live within the district before August of 2025?
I lived at 28170 Spring Creek Place in Pierre. Or not in Pierre, but that's the address. It's not in Pierre.
And where is that located within the district looking at Exhibit 103?
It would be at the very west end of the Spring Creek Road, again, northwest of the state marina campground area.
Did you personally own that property?
Objection, relevance, as this is far beyond the scope of the four factors at play here.
I'll sustain that objection.
Mr. Utek, at one point, did you petition the sanitary district to exclude the property that is to be developed as Codger's Cove, Codger's Castaway RV Park? Did you petition to have that property excluded from the sanitary district?
Yes.
Objection beyond the scope of direct and relevance.
I'm gonna overrule it.
May I give everyone a set of exhibits?
Yeah, sure.
These are all the exhibits that the petitioner identified and I'm not going to offer all of them, but I think it's easiest if I just hand you the packet. Mr. Utek, I'm going to show you what's been marked as Exhibit 210. Can you identify that?
Mr. Chairman, if I may have a standing objection to the testimony relating to this exhibit.
You would say that again, please.
May I please have a standing objection in relation to the testimony on this exhibit, as well as the objection, or as well as objection to the exhibit itself, although it hasn't been offered yet.
Yes, you may.
Can you identify Exhibit 210, Mr. Utek?
Yes, this is a petition to be removed from the district.
All right, and who submitted the petition to the district?
I did, or legal counsel, I guess.
And what's the date when that was submitted to the district?
I'm not sure if it's on here, and if I'm not seeing it or I don't recall the exact date.
Mr. Chairman, I renew my objection to this line of
I
testimony.
would sustain the objection.
I'm sorry,
Sustaining counsel's objection.
and which objection in particular? To the exhibit itself?
To this line of questioning regarding.
Questioning.
So, I've not offered the exhibit.
Well, I think her objection was to your question, though.
So my last question was what the date of when the petition was submitted to the sanitary district.
Well, I'm gonna sustain an objection, you can get the evidence in through your own witnesses.
All right, that's fine.
I just need a moment of clarity for the record. So the objection, Ms. Hagee, that you have pending is you objected to this line of questioning, correct? And that, when I say this line of questioning, I'm referring to this petition to be excluded from the sanitary district, is that correct?
Yes.
Okay, and is that the objection that you sustained?
That's the objection.
So then that would mean that this line of questioning that you're pursuing has been objected to, the objection's been sustained, so in other words, you have to change your topic.
Understood, thank you. Mr. Utek, at the time that the legal entity that you testified about earlier purchased the property, the former Speedway property, to be developed as Codger's Castaway RV Park, did you anticipate that water and sewer service would be provided by the Spring Creek Cow Creek Sanitary District for that development?
No,
And why not?
because it's,
Objection, relevance, and outside the scope of draft.
Overrule this one.
could you ask the question again, please?
Sure. The question was, at the time you purchased the racetrack property to be developed as the RV park, Codger's Castaway RV Park. Did you intend that that the development would be served by water and sewer from the sanitary district, and you said no, and I asked you why not?
Yes, I did say no. Why not? Because there isn't any water or sewer system available that's adequate for this project anywhere near this property.
I have no further questions for Mr. Utek at this point. Thank you.
Thank you, Mr. Moore. Questions from the state?
I have no questions.
Ms. Hagee, you redirect?
No redirect.
Any questions from the board? Hearing none, do you have any additional evidence, Ms. Hagee?
I do not, but at this time, I would renew my request I would request approval of the application at this time and have a standing objection to, if that is not granted, have a standing objection to all evidence and testimony offered, by the petitioner in this matter.
So you're renewing your motion to dismiss?
Yes.
Do I hear a motion to? You can deny that motion. And what was your second, Newt?
I would request a standing objection as to all testimony and evidence presented by the petitioner in this matter for purposes of relevance.
Deny that motion. We got that in the record. You understand the objection, sorry.
Thank you.
This time, does the board wish to take a lunch now, or we want to proceed with evidence with Mr. Moore's client? Any thoughts?
If we don't have lunch, I need a 2-minute break.
Counsel, you want to proceed forward, you want to push forward, or?
I defer to the board and other council parties.
I'm happy to proceed, Mr. Chairman. I've got a fair number of exhibits to go through with Mr. Schneider, so his testimony is going to take longer than the previous witnesses, I think, but I don't expect to be here all afternoon.
Sir, you're released too as a witness. Let's break for, let's take 30 minutes break. We'll reconvene at 12:40. For recess as of now.
Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net. You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net. You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net. You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net.
meeting back into order. Mr. Moore?
You call Todd Schneider, Mr. Chairman, thank you.
Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. It's a good way to start.
Can you introduce yourself to the board, please?
Todd Schneider, Schneider.
Mr. Schneider, how old are you?
65,
What's your occupation?
retired.
Where did you grow up?
Humphrey, Minnesota, small town in southwestern Minnesota.
Did you graduate from high school there?
Yes, 1978.
And what did you do for your education after you got to high school?
After high school, I went to South Dakota State University. At the time, I had two passions, wildlife and fisheries, and the other one was flying. I got my bachelor's in wildlife and fisheries in 1982. And then after that, a mentor of mine offered me an assistantship, Ray Linder, and I stayed and did a master's degree. And the thesis was designing shelter belts for the habitat of pheasants.
What year did you get your master's degree?
85.
And what did you do after that?
I worked for the Fish and Wildlife Service in Madison, South Dakota for a little while, and my other passion, flying, I got accepted into, based on testing and stuff like that, the Air Force would send me to pilot training. So I elected to do that.
And how long were you in the Air Force?
I served 14 years, both in the active duty and reserve.
And what did you do as a member of the Air Force?
I was a pilot.
What year did you separate from the Air Force?
I separated active duty in 93, and in the reserve it would have been probably about 2000, and yeah, 2000.
And what did you do after that in terms of employment?
I flew with Sun Country Airlines, and then I got hired in 1995 with United Airlines, and I flew for them for 27 years.
Where were you based when you were flying commercially for United Airlines?
Primarily Chicago. Some of it was also in Denver.
And where were you living at the time?
I was living in Colorado for a short period, probably about 8 years of my initial being hired. And then we moved to Brookings, South Dakota.
What year did you move to Brookings?
The 2005.
And while you were flying for United Airlines, what kind of planes did you fly?
All the Boeing ones. 737, 757, 767, 77, 787.
Do you still live in Brookings?
No, I live here in Pierre.
And how long have you lived in Pierre?
About 7 years.
And where is your residence in Pierre?
220 Darren Street in Spring Creek.
And is that within the geographic limits of the Spring Creek, Cow Creek Sanitary District?
Yes.
Are you married?
Yes.
Do you have children?
3 children, 2 boys and a girl.
Are you a full-time resident of the sanitary district?
Yes.
Mr. Utek testified that he thought 75 to 80% of the population was seasonal and not there in the winter. Is that consistent with your observation?
No, I would say personally it was around half, 50%. There's a exhibit from Bartlett and West, and I think they said it was 46% when they did the study in 2021.
Can you speak up just a little bit?
Are you currently on the Board of Trustees for the Spring Creek, Cow Creek Sanitary District?
Yes.
And how did you first become involved with the sanitary district?
I had gone to several meetings and was interested, just kind of finding out for myself what was going on. You hear a lot of rumors, and I'd like to find out the truth, what's actually going on. So I went to a lot of meetings, and then I got approached by people requested me to be on the board.
So when were you first elected to the Board of Trustees?
A little over 2 years ago, 20.
And have you also been an officer for the sanitary district?
Yeah, I was president for this past year, and last month I resigned being president, and then they elected me as vice president.
And who currently is the president of the board?
Kathleen Shue.
How many board members are there?
5.
And are the board members paid or volunteers?
Volunteers.
Has Vic Utek been on the board?
Yes.
Was he on the board in 2020?
I believe so, yes.
Mr. Schneider, can you look at Exhibit 103, please, and describe for the board the geographic extent of the Spring Creek, Cow Creek Sanitary District? 103 is the aerial photograph that was admitted into evidence previously.
On the east side, it's basically boundaried by 1804, and then it goes up basically to the north of the former racetrack, cuts across through Cow Creek, includes the peninsula, and there in the bottom center where it basically says Google Maps, you take that back to the east, basically to 1804 is the boundaries.
And are there currently residential and recreational developments within the sanitary district?
Yes.
And can you just tell me what those are?
Restaurants, state parks, 2 state parks, permanent residents, part-time residents, RV parks. Cool, total mix of people.
Would you look at Exhibit 219, please?
Okay.
What is Exhibit 219?
It's the order for organization and incorporation of Spring Creek, Cow Creek of Hughes County and Sully County, South Dakota.
And what date does it show that the sanitary district was incorporated?
7 July 2020.
And is there a legal description that is included there that that defines the extent of the sanitary district?
Yes, on the bottom of the page.
I'd offer Exhibit 219.
Any objections?
Yes, objection is to relevance and outside the scope of this board's authority.
I'd make that same objection.
All overruled, objection 219 is admitted.
Mr. Schneider, the Exhibit 219 refers to the sanitary district as organized as a governmental subdivision of the state of South Dakota and a public body, corporate and political. Do you see that?
Yes.
And what's your understanding of the legal status of the sanitary district as a political subdivision of the state?
I would agree. I mean,
What powers and authority does that give to the sanitary district?
the board has a district to enact and enforce ordinances, resolutions.
And has the board done that?
Yes.
How frequently does the sanitary district board of trustees meet?
The second Wednesday of every month.
And are those meetings, is notice of those meetings published?
Yes.
Are minutes of the meetings kept?
Yes.
Are they publicly available?
Yes.
Does the board comply with the open meeting laws of South Dakota?
Yes.
Does the sanitary district have any employees?
Yes.
How many?
2.
And who are they?
Forrest Zuber is our
I'm
superintendent.
sorry, start over again. Who?
Forrest Zuber is our superintendent, and J.J. Lynn with Anderson Nill and Associates is our accountant / clerk.
And are they both full-time employees?
Yes.
What does the superintendent do for the district?
Day-to-day maintenance issues, reads meters. He's the technical expertise for the district.
And what does J.J. Lynn do as the clerk?
Records the notes on the meeting minutes, publishes the minutes, keeps records of the district's things that go from day to day.
Does the sanitary district adopt an annual budget?
Yes.
And just in approximate terms, what's the income and expense associated with the district?
approximately, without the surcharges or the loans, approximately $400,000 annually.
Do you know personally Vic Utek?
Personally, professionally, yes. We've never,
How do you know him?
through board, dealings with the boards and working with them on that.
Does he regularly attend board meetings?
Yes.
And has he submitted development proposals to the sanitary district board?
He has.
Are you familiar with the developments that he is associated with in the district?
Yes.
And what are those developments?
Well, currently the first one, to my understanding, was Codger's Cove. And then there's Codger's Castaway, there's Codger's Caddy, and then there's Codger's Castaway RV Park. I don't think I forgot any.
Would you look at Exhibit 213, please?
Okay.
Can you identify that?
Codger's Castaway.
Yeah, what's actually shown here on this plan sheet?
Mr. Chairman, I'm going to object as to relevance, as this is not even related to the RV park.
Yes, 213. I have not offered it yet.
Never mind.
Did I just?
No. Okay, no, I apologize.
Overruled.
What was that question again? I forgot.
Sorry, I got ahead of myself, that's my fault.
What's shown on Exhibit 213 with respect to Codger's Castaway?
The blue area is the approved phase 1, and on the bottom, the yellowish tan area is the approved phase 2, in which there's water and sewer in that entire area.
So when you say approved, what do you mean? Approved by whom?
The sanitary district, Mr. Utek brought plans for the first phase was 75 and then an additional 18 or 19 lots after that.
How many lots are included in phase 1?
75.
Mr. Chairman, now I will object as to relevance for this line of questioning as to this is the residential housing development not related to the RV park.
Tied together, I mean, I'm not sure. The relevance is kind of unclear at the moment for me.
Well, one is that Mr. Utek testified that the sanitary district does not have the ability to serve the RV park, which is immediately to the east of this development, with water and sewer. So I think it's relevant to that. And it's relevant to a course of dealings related to
I'm sorry.
development
It's
plans.
relevant to what?
A course of dealings related to development within the district.
Overrule objection for now.
I'll offer 213.
Objection overruled, 213 is admitted.
Mr. Schneider, one more question about Exhibit 213. Do you see the area to the east of the platted lots that's denoted as Tract 2?
Yes.
And what is that area, just for the record?
That's the proposed Codger's Castaway RV park location.
All right, thank you. Would you look at Exhibit 201, please?
Okay.
Can you identify that, please?
Yes, resolution 2024-5.
Of the sanitary district?
Yes.
And what's the date that the resolution was adopted?
20th day of November 2024.
And did you sign the resolution? Were you president of the board at that time?
Yes.
And what is the subject of the resolution?
It's requiring all premises to have water and sewer service available to the premises through the Spring Creek, Cow Creek Sanitary District.
And where is that stated in the resolution?
Well, that's the title, and then if you go into the numbered stuff, number 1 talks all premises or water service and or sanitary service is intended to be installed within the jurisdictional boundaries shall be directly connected to the public water and wastewater collection and treatment system of the district. And that's kind of the gist of it, but it goes on.
And if you would look specifically at paragraph 5, what does paragraph 5 provide with respect to development?
All plans for development submitted to the board involving a planned development of property which is not immediately adjacent to a connection to the district system must include plans for the extension of the district system to provide water and wastewater collection to the planned development.
And what do you recall about why this resolution was adopted by the sanitary district?
Clarity?
Meaning what?
Clarity, we'd heard in a small community, you always hear rumors, innuendos and stuff. And we'd heard rumors that there might be some additional stuff, developments using their own water, their own sewer, their own this or that, or not using any, or not connecting. And we wanted to clarify that if you are in the district, you're required to have water and sewer connected to our system.
I'll offer exhibit 201.
Relevance objection.
Overruled. Exhibit 201 submitted.
Could you look at exhibit 218, please?
Okay.
What is exhibit 218?
Meeting minutes of Wednesday, November 20th, 2024.
Of a meeting of the sanitary district board?
Yes.
And was the resolution 2024-5 considered at this meeting?
Yes, on page 1, 2, 3, second paragraph, or I guess the first full paragraph. Almost that whole third page is the discussion on 2024-5, which was the resolution we just talked about.
And was Mr. Utek present at this meeting?
Yes.
I'll offer exhibit 218.
Objection, relevance.
I would also object to relevance of the meeting minutes.
No, we'll objection 218 submitted.
Would you look at exhibit 206?
Okay.
What is exhibit 206?
Ordinance number 7 of the sanitary district.
And when was ordinance 7 enacted?
December 14th, 2022.
And what is the subject of the ordinance?
Regulation of water use.
Would you look at Article 4, Section 1 of the ordinance, please? And Mr. Schneider, without reading it into the record, what generally does that provision of the ordinance provide?
Every property owner has to connect to our water and sewer.
And would you look at Article 6? And just in general, what is addressed in Article 6 of the ordinance?
By connecting, you've consented to the rules, regulations, rates, fees, charges, and rentals contained in our ordinances passed by the district.
Was there a similar ordinance in effect before this one requiring that human occupied structures within the district connect to the water and sewer systems of the district?
I was not involved in that. I believe there was, but I do not know.
Okay. I'll offer exhibit 206.
Objection relevance.
Objection, please state.
Not to this one.
Objections overruled, exhibit 206 admitted into evidence.
Mr. Schneider, could you just describe in general for the board the systems that are currently in place within the sanitary district to provide water and sewer services to members of the district?
I'm gonna object to testimony about the sewer system that has, that the water right has nothing to do with the wastewater aspect.
I'm gonna overrule that objection for now. You may answer.
Do you recall the question?
Yes. We just recently completed a water tower for the district, new water tower, the only water tower. And we are currently in the final stages of completing a new sanitary treatment facility.
And when did that work start?
A little over a year ago.
And what's your understanding of why the district undertook those improvements?
My understanding is the Codgers Castaway development was approved by the state. Or initially it was denied by the state because there wasn't the capability up there for that. Therefore, we started developing the water tower and specifically the sewage treatment facility because of Codgers Castaway, particularly also the Codgers Castaway RV park. And this increased demand caused an increase of debt for us of $3.62 million.
So, would you look at exhibit 214, please?
Okay.
What is that? Can you identify it?
It's a study done by our engineering firm, Bartlett and West. Started in 2021, and what was initially proposed in 2021 was to reline the pond. Subsequently after that, Codgers Castaway was approved. Relining the pond was no longer a valid option, and the state said that we had to have a larger system to take part, because in this study, it says the population equivalent which they used would be almost double what we were at the time if Codgers Castaway and the RV park were developed.
And are the improvements that you testified about previously with respect to the water tower and the sewage treatment?
With respect to the what?
The water tower and the sewage treatment, are those addressed in exhibit 214?
Yes.
I'll offer exhibit 214.
Relevance objection.
We sustain that objection. 214 is not amended.
Mr. Utek, Mr. Schneider, would you look at exhibit 217, please?
Okay.
Can you identify this?
Department of Ag and Natural Resources, it's a denial for the plans for Codgers Castaway, the way I understand it.
And specifically, when you say Codgers Castaway, what development are we talking about?
It just says Codgers, on top it's Codgers Castaway subdivision, and then in the plans it talks about in the first paragraph Codgers Cove. But it'd be, my understanding is this is Codgers Castaway.
And you previously testified that the Department of Agriculture and Natural Resources had denied plans because of the capacity of the sanitary district. Do you recall that?
Yeah, yes.
And is Exhibit 217 associated with that testimony?
Yeah, it's the bold statement in that second paragraph.
And what happened when this was submitted?
When this was submitted, then this was denied, and then Department of Ag and Natural Resources then said that we needed to build a bigger, larger system, which we're just about complete with now.
I'll offer Exhibit 217.
Relevance objection.
I'm also gonna object to that one. The scope of the water right ends at the appropriation and beneficial use. The wastewater doesn't factor into it.
Sustained objection, 217.
Would you look at Exhibit 220, please?
Okay.
And what is Exhibit 220?
Calculations by J.M. Smith Engineering, Mr. Utex engineer for lift station,
For what development?
Rogers Castaway.
And on page 2, does it show the number of lots and camper sites proposed to be developed?
Mr.
Yes.
Chairman, I'm gonna object as to lack of foundation to testify from this document.
Sustained.
All done?
Would you look at Exhibit
202.
Yes.
Okay.
Can you identify that?
Resolution 2024-2, giving us, for the funding.
Funding for what specifically?
I'm looking to see if this was the CW or the DW. It's for the revenue bonds, but I was looking to see if it was for the water tower or the sewage treatment. We have 2 bonds for water tower and 2 bonds for sewage treatment facility.
And what was the amount of the bonding at issue in Exhibit 202? Stated in paragraph 3.3.
Which paragraph?
3.3.
Oh, 3.627 million.
And could,
So the, go ahead, sorry.
did the district issue bonds
Yes,
for the project in that amount?
yes,
And would you look at paragraph 10.3, please?
okay.
What does that paragraph provide with respect to the obligations of the sanitary district and requiring that users within the district use the services of the sanitary district.
It restricts us, basically saying that until payment is full of the principal and interest of the bond, the district agrees not to sell or dispose of the project, or shall not establish, authorize, or grant a franchise for their operation of any other utility supplying like products or services in competition therewith. And it goes on, or permit any person, firm, or corporation to compete with it in distribution of water for municipal, industrial, domestic purposes within the sanitary district.
And is that an obligation imposed on the district as a result of receiving the funds identified in this resolution?
Yes.
Objection calls for a legal conclusion.
Sustained.
What's the date of the resolution?
May 8th, 2024.
Offer Exhibit 202.
Objection relevance.
I'd also object as it relates to wastewater.
Ms. Hagy, do you have an objection to?
Objection relevance.
Sustained. 202 is not admitted.
Offer, well, would you look at Exhibit 203, please?
Okay.
And can you identify that?
That's one of the other resolutions that we have for bonding, and this one's for the water tower.
And what was the amount at issue in this resolution?
I think this one, if I read 3.1, it says 300,000.
Yes. And what's the date of the resolution?
January 10, 2024.
And if you look at paragraph 10.3, does that contain the same restriction as in Exhibit 202?
Yes, it does.
I'll offer Exhibit 203.
Relevance objection.
Okay.
I don't have an objection for this one.
Mr. Moore, do you have any comments on that objection? What makes it relevant?
Well, again, it explains the district's financial interest in ensuring that users in the water district connect to the water and sewer services provided by the district, and in fact, the promise that the district made to the state of South Dakota as a result of receiving those loans, and I think that's relevant to the public interest.
Then I'm going to overrule objection. 203 is admitted.
Would you look at Exhibit 204, please?
Okay.
What is that?
That's the bonding resolution for the clean water facility, which would be the sewage treatment facility.
And what's the date of the resolution?
August 10th, 2022.
And the amount of the amount that was at issue here, what is that?
$1,232,860.
And does this resolution contain the same language in paragraph 10.3 as exhibits 202 and 203?
Yes.
I'll offer exhibit 204.
Objection relevance.
I'd also object for relevance.
Mr. Moore, explain to me why it's relevant.
The same reasons that I previously argued, Mr. Chairman.
Objections overruled. Exhibit 204 is in.
And would you look at exhibit 205?
Okay.
Would you identify it?
Yep. That's the bonding resolution for drinking water, which is the water tower.
And what's the date of the resolution?
August 10th, 2022.
And what is the amount involved here?
$2,220,000.
And again, is paragraph 10.3 the same as in the previous three exhibits, 202, 203, and 204?
Yes, it is.
I'll offer exhibit 205.
Objections? I'll admit 205. Objections overruled.
would you look at exhibit 225, please? Can you identify that?
It's a summary of the current grants and loans for the Spring Creek, Cow Creek Sanitary District.
And does it show amounts specifically related to the improvements to the facilities that you previously testified about?
Yes.
I'll offer exhibit 225.
I would object for foundation relevance.
I'm sustain that now.
Just working with the foundation.
Sure. Mr. Schneider, where do the amounts that are included in exhibit 225 come from?
The bonding resolutions.
And what, do you know who prepared exhibit 225?
No.
Is it
Not sure.
maintained in the records of the sanitary?
It is through the bonding resolutions, you can find it, but in a succinct form like this, I don't know.
All right, but the numbers that are stated in this exhibit are essentially from the resolutions that we've been talking about.
They're accurate as far as I know, yes.
All right, so I'll reoffer 225.
I would object still for foundation as well as relevance, as this is, also includes the sanitary sewer numbers that were previously, the exhibits that were sustained through objection.
State.
I would object based on that. The sewer numbers, they're just not relevant.
I'm a sustain it to foundation.
Mr. Schneider, would you look at exhibit 210, please?
Okay.
What exhibit?
210? Yeah. What is that?
A petition for exclusion of real property from the Spring Creek, Cow Creek Sanitary District.
And specifically what property?
Codgers, Castaway.
Is this the proposed RV park?
It would be part of it.
And when was this presented to the sanitary district?
Objection relevance is to this line of questioning.
I'm gonna overrule that.
I don't see a date it was presented to the district, but it was filed on June 7, 2023.
It was filed in
Sully County.
Sully County, correct?
Yeah.
You see the notary on the third page of the exhibit just above
Yes.
that,
February 22nd.
notarizing the signature of the petition circulator.
Yes.
And that date is what?
February 22nd of 2023.
All right, I'll offer exhibit 210.
Objection relevance.
Okay,
I don't object to this one.
Mr. Moore, can you explain to me the relevance of this document?
Yes, Mr. Utek sought to exclude the RV park from the district, and there are several exhibits here that go together that show that the district voted on that, denied the exclusion. There was a notice of appeal to circuit court from that, and then eventually the circuit court appeal was dismissed. And I think it's, again, relevant to show efforts the sanitary district has made to protect its interest in serving residents of the district.
210's admitted.
Mr. Schneider, if you look at exhibit 209, what is that?
Meeting minutes, May 10th, 2023 for the sanitary district.
And was the petition to exclude that is marked as exhibit 210 discussed at this meeting, and voted on
Yep.
May 10th, 2023.
Yes.
I'll offer Exhibit 209.
Objection relevance.
State have any?
No.
I'm gonna admit 209.
And, what was the decision of the sanitary district on the petition to exclude?
They voted to not allow the exclusion. In other words, the way it was, that paragraph, decision on the proposed exclusion was tabled. The board will reconsider the proposed, and they voted to not allow Mr. Utek to get out of the district.
And was Mr. Utek present at that meeting?
Yes.
Would you look at Exhibit 211, please?
Okay.
And can you identify that, please?
6th Judicial Court, denying the petition for resolution of exclusion of real property.
It's captioned Notice of Appeal, correct?
Pardon?
It's captioned a Notice of Appeal.
Yes.
And it's from the decision on May 10, 2023, denying the petition for a resolution, correct?
Correct.
Was the sanitary district represented by counsel in connection with this appeal?
Yes.
I'll offer Exhibit 211.
Objection relevance.
I'd also object on relevance.
No movable objection, admit 211.
And could you look at Exhibit 212, please? First of all, Mr. Schneider, what's your understanding of what happened to the appeal that was filed from the sanitary district's decision denying the petition to exclude property from the district?
To my understanding, and I wasn't involved at the board at that time, but going back through this, I understand that they had filed with the Circuit Court, the 6th Judicial Court, and there it sat with no action for a period of 1 year, then it was dismissed, to my understanding.
I'll offer Exhibit 212.
Relevance objection.
I'd also object to relevance.
I'm gonna admit Exhibit 212.
Could you look at Exhibit 222?
Okay.
Can you identify that?
Yes.
What is it?
It's my letter to Mr. Utek that we had received incomplete plans for a proposed RV park. And we could not grant approval, and we asked him to please provide plans showing a direct connection to the district for review and approval.
And what if you can just explain further the basis for the denial, what was the issue with the plans and specifications submitted by Mr. Utek?
There was no connection to the water and sewer of the district.
I'll offer Exhibit 222.
Objection relevance.
I'd object as it relates to the wastewater.
I'm gonna overrule the objections and admit 222.
Mr. Schneider, is the sanitary district opposed to the development of the RV park, referred to as Codger's Castaway RV Park?
Absolutely not. We encourage development that helps us pay the loans.
And with respect to the permit application that is before the Water Management Board today, why did the sanitary district decide to file a petition opposing the application?
Because the district felt that it would harm every individual within the district because the size of the development, the infrastructure of almost $7.2 million was as a result of the planned developments, both Codger's Castaway, Codger's RV Park, potentially Codger's Caddy, and that was required of us to have a 15-year lookout plan. And we made the size of our infrastructure to fit the plan that was already been approved by the state.
Those are all the questions I have for Mr. Schneider. Thank you.
Thank you, Mr. Moore. Ms. Heggie?
Good afternoon, Mr. Schneider. First, I want to start with your statement that the district does not oppose the development of the RV park. You said absolutely not, right? Correct?
We don't oppose any development as long as it fits within our ordinances.
You encourage it.
As long as it fits within our what?
Ordinances?
You encourage development and it helps you pay the loans.
Yes.
Back in 2021, you signed a petition submitted to the county that opposed all of Vic's development out there.
I signed that petition because for the increase of the sewage treatment facility that was within a block of our property.
It was, I'd say it's a kind of a NIMBY, not my backyard petition. Would you categorize it as that?
A group of people got together and signed it, yeah.
Okay. You're scared of the area would lose its aesthetic appeal.
I'm sorry, you have to talk a little
Yep. You believed that the area would lose its aesthetic appeal.
Okay, I don't remember specifics on that. That was 3 years before I was on the board.
You believed your investments would be negatively affected in the future because of the developments.
Not because of his development, because the increased sewage that was in the lagoons close to our home.
You were concerned with the increased traffic in the area.
I don't remember that part.
But you agree you signed a petition opposing, or asking the county to oppose fixed development, including his campsite.
I asked to oppose the increased sewage in the sewage treatment facility next to our home.
Does the county regulate the sewage treatment facility?
In 2021, I don't remember because I wasn't involved if it was Hughes County or if it was the board at that time or who it was.
You also, prior to serving as the board of trustees, well, let me go back to this. Are you aware of any other board or trustees on the sanitary district board that signed the petition with the county?
Not 6 years ago, no.
Prior to serving as a trustee on the board, did you threaten legal action against the sanitary district for its approval of Vic's other plans?
No.
Did you have raised any concerns with them about Vic's? I'll ask that one. Now, your position here today is that the new water tower and the new sewer system were pursued because of Vic's planned developments, correct?
Partly the water tower part of it, but significant part of the sewage treatment facility, yes.
I'll have you turn to Exhibit 214. Mr.
214's been refused, Mr. Chairman.
Correct.
Has been received?
Has been refused.
Yeah, that's what I thought.
Yep, it is.
So object to questioning about 214.
I think I can still use it as impeachment purposes, Mr. Chairman.
Let's see where it goes.
You could turn to page 4 of Exhibit 214. Would you agree that this is the lagoon improvement plan that you were talking about earlier?
This was what?
The lagoon improvement plan that you were talking about earlier.
Yes.
Okay. And on page 4 of that, it talks about the general purpose of the recommended improvements is to bring the system back into compliance with the existing permit as a non-discharge system. More specifically, addressing concerns with the lagoon liner and dissipation of effluent that is noted to be more than anticipated by evaporation. The focus of this study are improvements to the lagoon system needed to meet Dana requirements. And the sanitary district should also continue to maintain the collection system, improve metering at the lift station, and investigate possible inflow and infiltration issues. Is that what that says?
I guess you read it, yeah.
Does that make any mention of the purpose of this is for Mr. Utek's plan developments?
Not in that statement.
How big is the water tower, the newly constructed water tower?
I believe it was constructed at 200,000 gallons.
And are you aware of a study done relating to options for that new water tower?
I was not on the board, no.
You've reviewed the Bartlett and West Lagoon Improvement Study, correct?
I've reviewed through this, yes.
And on the sanitary district's website, there's a corresponding Bartlett and West drinking water facilities plan from that December 2021 date as well.
Okay.
Are you familiar with that? Have you
No.
looked at that?
Again, that was 3 years before I was on the board.
If I handed you a copy of it, could you tell me if you've seen this before? Have you seen this document before?
No, I don't remember reading this document or referring to it in my term.
Do you know of documents that are on the district website?
Most of them, not all of them.
Do you believe, if I represented to you that this is on the sanitary district website, would you have any reason to disagree with me?
I have no reason one way or the other.
Page 1 of this plan, if you could turn to page 1. It provides a project executive summary. Are you on page 1?
Well, is it before the map?
It has a
There it is, okay.
number 1
Yep,
in the
got
bottom
it.
right-hand corner.
Yep,
So that first paragraph of the project executive summary indicates that the system has one 57,000 gallon ground storage tank. It's nearly 30 years old, nearing the end of its lifespan, and has experienced several leaks in the last few years. Do you see that?
Are you intending on offering this as an exhibit, or what you're using it for?
I'm using it for impeachment. I believe it's a document that the district has, and it's posted on its website, so I believe there's sufficient foundation for it.
We'll let it go for now.
If you look at the third paragraph, it talks about increasing the system storage to 200,000 gallons will provide capacity to compensate for high demand days and greatly increases the reliability of the system to provide potable water to customers. Do you see that paragraph?
Where it starts off, it is also recommended.
So let's move down to that one next. Yep, it's also recommended that an alternative option for a larger 400,000 gallon tank be bid, along with the recommended 200,000 gallon tank, which meets the existing system needs.
Okay.
A larger alternative tank would assist with addressing the issue of future developments at the Spring Creek, Cow Creek Sanitary District. Would you agree with that, with what's?
That's what's written there,
I'll
yes.
just object to foundation, I guess.
He'd sustain that objection.
Would you agree that the 200,000 gallon tank was built to serve the existing needs of the system? And that a larger 400,000 gallon tank was proposed as an option to accommodate future developments in the district?
I wasn't involved in that decision in any way. But everything I've heard since, in the last year, that the 200,000 one is sufficient for 15 years.
You provided testimony that the decision to go with the 200,000 gallon tank was because of.
I said in a very small amount was that, but the majority, almost exclusively, was a sewage treatment facility. That was exclusively Dukatcher's Castaway.
So the sewer aspect, not the water aspect.
In that case, for the design thing for that, it was my understanding, and again, I wasn't there, I wasn't involved in the decisions. There was some on the water, but primarily on the sewer.
So probably the board members at that time would have a better understanding of why those decisions were made.
I would
Is that
guess. I would guess.
Mr. Moore went through a number of resolutions and ordinance 7 with you. Is it the district's position that everybody within the sanitary district boundaries has to hook up to the sanitary district system?
If it's intended for, to be a home or residential area, yes.
I will have you turn to Exhibit 206. Article 4, Section 1. Do you agree that that provision says every owner of houses, buildings, or other structures used for human occupancy, employment, recreation, or for other purposes situated within the sanitary district and abutting a street, alley, or right-of-way shall connect the same directly with the proper water main in accordance with the provisions of this ordinances. Continue on, provided that said water main is within 400 feet of the property line.
That's what it says.
So pursuant to Article 4, Section 1, owners of those structures are not required to hook up to a water main if it is past 400 feet.
That's what that said, and then Resolution 2405, if I remember the correct number, clarified that.
Are you aware whether a resolution can supersede an ordinance?
We just tried to clarify it, to my understanding.
But it changed it, would you agree? Was that the board's intention?
Just object to foundation for this witness.
Not sustain that.
Would you agree, well, in your role as president and now vice president, were there certain construction design standards that the board approved relating to the infrastructure in its district.
Yes.
And are you familiar with the requirement that all water mains be a diameter of 6 inches?
I believe so.
How far away from a 6-inch water main is the Codgers Castaway RV Park?
I don't know off the top of my head.
So you don't know if it's within 400 feet or exceeding 400 feet?
I'll check it out, it's fine. I'm not overall objection.
I don't know. There's hearsay that there's water closer, but I cannot guarantee that answer.
So the district's position doesn't account for Article 4, Section 1, that allows a 400-foot rule, essentially.
Not at this 400 feet on this one.
There was some discussion about the bonding requirements and it's essentially a requirement that the sanitary district make sure everyone hooks up to your system for those state loans. Do you remember that?
Which one was that? Which?
So Mr. Moore had asked you questions regarding the bonding requirement relating to the sanitary district requiring all of its users to hook up to its system.
We couldn't allow opposing on the bonding requirement.
And is it your?
Competing systems.
What did you say?
We couldn't allow opposing or competing systems, was the bonding resolution.
And is it the district's position that that's why you're here today, is partly to comply with your bonding requirements?
I would say it's partly because of paragraph 10-3, because we're trying to comply with our bonding resolution required by the state. And, well, I'll just leave it.
Now, there's a number of other, let me take a step back. Have you reviewed the engineer's report that was the technical review provided by the Water Rights Program in this matter?
No.
Mr. Setchi had testified earlier as to his report. You haven't seen that? Okay. Are you aware of any other water rights permits that are issued within sanitary district boundaries?
Water rights permits? Are you meaning wells or water right permit? I'm confused at the question.
Water permits, water appropriation permits issued by this board or the South Dakota Water Rights Program.
I think he said in testifying earlier that there was one other one within the district, and I don't know.
Has the district taken any enforcement action against anyone else regarding other water rights or permits that they may have? Mr. Schneider, are you aware of the prior use of the proposed Codgers Castaway RV Park, that it was previously used as an RV park before Mr. Utek purchased it?
My understanding, it was a racetrack.
Are you aware of whether there were RV spots at that racetrack?
There were during the races, which was, to my understanding, what Sully County said that was a special issuance and waiver from the state, is what my understanding was, and I don't know if that's accurate or not.
Those campsites weren't hooked up to the sanitary district, were they?
What's that?
Those RV parks or the RV hookups weren't connected to the sanitary district services, were they?
I don't know. getting back to resolution 2024-5 and the 400 feet. In the meeting minutes of 11/20/24, legal advice at the bottom of that third page again. I'll read it to you. It says, Miller, who is our attorney, stated that the 400 feet is irrelevant. If you're within the district bounds, you're required to hook up to the system. That was the legal advice that we were given.
Are you aware of an ongoing court proceeding, through the federal court, that is between Mr. Yutek and some of his entities versus the sanitary district system?
Some of what? I'm sorry.
And some of his entities with the sanitary district.
Mr. Utek and some of his entities against the district? Yes, my understanding is there's 2 federal suits.
And regarding one of them addresses the sanitary district ordinances and resolutions regarding the requirement to hook up to the sanitary district system. Is that fair?
Which one is that?
Are you aware of that is one of the suits?
If, I believe so, if I understand what you're asking.
Are you aware of a court date coming up in that matter?
What I know is June 9th, I think, is a preliminary injunction, I believe.
And at that hearing, the court intends to address whether the RV park is required to hook up to the sanitary district system.
I don't know what exactly is gonna happen at this point.
I understand one of the main arguments that the sanitary district system, or the sanitary district is making, is that it is unfair for Mr. Utek to not be required to hook up to your system because there's bills to be paid. Is that fair?
As a result of Codger's Castaway and that development to include the RV park, we had to upsize the sewage treatment facility of $3.62 million.
That's relating to the sewage.
And that's the surcharge, and based on surcharge CW02, we have a bill due to the state of $18,500, give or take, every month.
And there's a tiered system for that surcharge, is that correct?
Yeah, you could say it was a tiered system.
And the biggest tier for the classification is, has to pay over $3,000 per month surcharge, correct?
Based on usage, strictly based on usage.
And Mr. Utek is the only user falling in that category and paying that amount, is that fair?
As he was the highest usage by far, yep.
Can the sanitary district force Mr. Utek to build his RV park?
Can we force him?
Yeah.
No.
So if there's no water permit, Mr. Utek isn't required to build something to pay the sanitary district bills, correct?
I'll just object to relevance.
I have no further questions.
Thank you, Ms. Agee. State, any questions of this witness?
I have no questions.
Mr. Moore, do you have any redirect?
I have a couple of questions, Mr. Chairman. Mr. Schneider, can you look at Exhibit 214, please? Ms. Hagee asked you to look at page 4 of that document. Would you look at page 8, please?
Okay.
And is there discussion specifically in the third paragraph about additional anticipated users to be served by the district?
Yes.
And could you just explain what's included in actually paragraphs 3 and 4 there with respect to proposed development?
The proposed development estimated to include about 450 new residential lots and 320 RV units, in addition. And that's, equal to the existing size of the system, so it'd effectively double our system.
And if you would look at pages 11 to 12, again, does the document talk about future design flows and the population base to be served by the system in the future?
Yes.
And what's the population that's stated there?
Again, it talks about 397 and 450, and then on the flows, it almost doubles on the flows from 956 to over 1600.
And look at
It almost doubles on the flows from what?
956 to 1600.
And if you look at the bottom of page 11, it talks about a total design population equivalent. You see that?
Bottom of page 11.
Yes. Very last thing on the page.
Yes, 900. The project design flows for existing and future are based on a total design population equivalent of 956.
And that's also reflected in the table on page 12, correct?
Yes.
Mr. Chairman, I'd reoffer Exhibit 214.
I'm gonna admit 214. Did you wanna make a record on that?
Oh, yeah, I'll object to relevance.
I'd continue to object because it's based on it.
Sorry, I got ahead of myself.
That's all I have for Mr. Schneider. Thank you.
Any additional?
One additional. Mr. Schneider, you just testified as to the lagoon improvements, facility plan prepared in December 2021 by Bartlett and West, correct?
2021 and amended on 2023, yes.
But the district is not offering any study regarding a drinking water facilities plan.
That's in an exhibit here.
So the only evidence. I have no further questions.
Say anything?
Nope.
More?
Nothing. Thank you.
Any questions from the board? Mr. Moore, do you have any additional witnesses?
I do not.
Okay. You can sit down, Mr. Schneider. At this time, I'm going to declare that the testimony and evidence is closed in this matter. I'm going to make a motion pursuant to SDCL 1-25-2
Subparagraph 3, to enter into executive session for the purpose of consulting with legal counsel regarding this matter. You are now adjourned.
Leo, I will give you a call again. You'll have to hang up.
Okay.
You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net. You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net. You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net.
Right, I hereby call the May 6, 2026 Water Management Board back into meeting. We're here about consideration of water permit application number 8987-3, Vic UTEC. Do I hear a motion to approve or deny the application? After considering all the evidence here today, I move to deny the application as it is not in the public interest, as it is in conflict with an ordinance that was issued by another public subdivision and the body politic of the state of South Dakota. Do I have a second?
Epler, second.
Can I have the roll call?
Comus,
Aye.
Dixon,
Aye.
Freeman,
Aye.
Hepler,
Aye.
Holzbauer,
Aye.
Larson.
Aye. Water permit application number 8987-3 is denied.
Oh, right, Mr. Moore, if you would prepare findings of fact and conclusions,
How many days, Mr.?
I would, if we could get those by the, May 29, and then we'll have, objections or, counter proposals for findings of fact and conclusions by June 10. Is that adequate time for everyone?
Yes. Mr. McVeigh, I do have a question about the exhibits that were admitted. I've not submitted the record exhibits for, I don't know who gets them, I guess. You all had copies, but I don't know where the official, it goes, all right, so I'll talk to Ron about that, thank you.
Thanks, folks.
Thank you.
Thanks, everybody.
I'm gonna go take care of that.
Yep.
Ron, can I?
You've got an extra one, I'll take it, otherwise we'll grab one.
Well, that's everything. Do you want me to? You'll take care of it? All right. You're much more accommodating than all court. They make us do it. So I appreciate that. Thank you very much.
Nicholas Fitzgerald.
Yeah, oh yeah, very well. I was thinking about you, yeah.
He's a client.
When I started hearing background, yeah, you do. Well, the last.
Take care of it.
Oh, yes. Well, I part of it. Oh, you are? Okay.
is the consideration of water permit application number 8991-3 Century Swine. We want to hear all of those. There's a second permit in here.
Well, there was motions to consolidate, and those motions were denied. I have to look at the orders.
We'll start with 9-1.
Yeah, I would start with 9-1. Is there gonna be overlapping, records between the two applications, or are these completely different from the engineering side?
They're completely different from the engineering side.
Okay, so
We'll do two then, okay. All right, we'll start with the application number 8991-3. Council, will you make your appearance on the record, please?
Emily Greco, counsel for the chief engineer and water rights program.
Paul Cheddar of the Boyce Law Firm for the applicant, Century Swine RE LLC.
And Connor Shaw for the petitioners, Cindy, Larry, and Garrett Hines, and also the petitioner Amanda Barca.
Thank you. Ms. Greco, do you wish to call witnesses?
First off, this is 8991. There was a few more petitioners. I was wondering if any of them were here.
I have 8991-3 is the first one on that agenda.
Yes. And there was a few more petitioners aside from the people Mr. Shaw represents, so I was just checking to make sure none of them were in the audience.
Is there anyone online, Ron? Or Amanda?
No.
Okay.
This is it.
So,
First, I'd move to admit Exhibit 1, which is the administrative record.
Any objections?
No objection.
No objections.
Exhibit 1 submitted.
Test.
I'd call engineer Austin Secchi. Can you state and spell your name for the record?
Austin Secchi, AUSTIN
And then I'll hand you what's been marked as Exhibit 2. Can you tell me what that is?
Curriculum vitae, or my curriculum vitae.
And did you produce that document?
I did,
And is it up to date?
yes.
And is there any corrections you think?
There would actually be a couple corrections. Underneath work experience, I would change the spelling of where to water rights program. And underneath that, instead of nature, to natural resource engineer. So,
I move to admit Exhibit 2.
my apologies.
Any objections?
No, Mr. Chair.
No,
You
Mr. Chair.
guys,
Exhibit 2 submitted.
okay. Can you describe your educational background?
I have a Bachelor's of Science in Industrial Engineering and Engineering Management from the South Dakota School of Mines and Technology.
And how are you currently employed?
I am a resource engineer for the Water Rights Department.
How long have you been with the water rights program?
Approximately 2 years.
What do you do for the program?
I help prepare technical documents for the chief engineer. I look at observation well data and also measuring observation wells, and also help with safety and an inspection of dams.
When you do these technical reviews, are you typically looking at groundwater sources or surface water?
Groundwater.
And then are your reviews, or your reports then reviewed by other people in the program?
Yes.
How many people typically peer review your reports?
6.
Are you familiar with water permit application number 8991-3 for applicant Century Swine?
Yes, I am.
Can you describe what this application proposes to do?
Water permit application number 8991-3 proposes to appropriate up to 154 acre-feet of water annually at a maximum combined pump rate of 0.5 cubic feet of water per second from one existing well and up to 2 additional wells to be completed into the Dakota Aquifer.
And then where and for what use does this application seek to appropriate water?
Water permit application number 8991-3 is located in the northwest quarter of the Northwest Quarter, Section 9, for commercial use in a swine facility located in the Northwest Quarter, Section 9, all in Township 121 North - Range 71 West. This site is located in Edmonds County, or approximately 10 miles southwest of Roscoe, South Dakota.
What was the scope of your technical review?
I look at the availability of water and the potential for unlawful impairment.
And I think you mentioned the source of this water is the Dakota Aquifer. Can you describe the size of the Dakota Aquifer?
It covers most of the eastern portion of South Dakota.
Does it also span under other states?
Yes, it does.
But your review was limited to the portion underlying South Dakota?
Correct.
Can you describe the thickness of the aquifer at this location?
The well completion report with this application lists a saturated aquifer thickness of 185 feet.
And is the aquifer confined or unconfined at this area?
It is confined.
What does it mean to be confined?
It has a confining layer in it that water will go above will go above the water level line in it, so water will be above just where the aquifer lies.
What is the head pressure?
Head pressure is the water above the aquifer.
Do you know what the head pressure is at this location?
It's over 1,000 feet.
And then are there flowing wells or springs at this location?
There are uncontrolled flowing wells.
What are uncontrolled flowing wells?
Uncontrolled flowing wells is where the pressure in the aquifer is great enough where it goes above the land surface and spills onto land surface.
How do you examine the availability of unappropriated water?
We look at the recharge and the withdrawals from the aquifer.
Generally, what is recharge and withdrawal?
Recharge is what water is going into the aquifer, and withdrawals are the sources that are coming out of the aquifer deliberately.
And then SDCL 46-6-3.1 prohibits appropriation of groundwater when the quantity of water withdrawn annually will exceed the quantity of average estimated annual recharge, but it provides an exception for water distribution systems located lower than the Greenhorn Formation. Is this source older or stratigraphically lower than the Greenhorn Formation?
The Dakota Aquifer is older and stratigraphically lower than the Greenhorn Formation.
And quickly, what is the Greenhorn Formation?
It's set as a marker for drillers.
So if it's older and stratigraphically lower, then why doesn't SDCL 46-6-3.1, the exception, apply?
It's because the applicant's proposed use is not in a water distribution system.
So in this case, you did still assess whether withdrawals exceed recharge, even though it's older or stratigraphically lower than the Greenhorn?
Yes.
When you examine recharge versus withdrawal, are you looking at a discrete point in time, such as a year, or are you looking to an average?
It'd be an average. It's an annual review.
Okay. Why do you look at an average annual review as opposed to an instantaneous?
Looking at an average of it gives us a little bit more details and understanding predictions. More of a historical approach of being able to look at it over time instead of one slice of moment.
How does the Dakota Formation or the Dakota Aquifer receive recharge?
Recharge to the Dakota Aquifer in South Dakota occurs through upward leakage from underlying aquifers, the Madison and the Indian Cara. With higher potentiometric surface than the Dakota Aquifer, downward seepage through overlying confining layers and through infiltration of precipitation on the Newcastle Formation that outcrops the Black Hills.
And what information are you relying on when assessing recharge?
Relevant studies into the Dakota Formation, Breda Hoft and others.
Say again, Breda?
Breda Hoft.
Based on the information that you have available, what is the estimated recharge?
Approximately 79.4 CFS, 57,500 acre feet per year.
And in your report, you mentioned Breda Hoft et al. 1983, which is the report you rely on in approximating that recharge number. You say that that is outdated. Does that worry you about this recharge estimate?
No, it does not. More recent studies that have been done show that there is even more recharge that could be going into the Madison and other aquifers, showing that this number could actually be low.
And the Madison is one of the aquifers that would cause recharge into the Dakota?
Correct.
Can you now describe withdrawals from this aquifer?
At the time of writing this report, there are 260 water rights permits and 7 future use permits reserving 4,287 acre feet of water from the Dakota Aquifer. Of the 260 active water rights and permits, 97 of them are primarily for water distribution systems, 21 for irrigation, 114 are for commercial use, 7 for industrial use, 10 for domestic use, 4 for fish and wildlife propagation, 2 for geothermal, 2 for institutional, and 3 for recreational.
Based on your review, what is the estimated total annual withdrawal?
The estimated average annual withdrawal from the Dakota Aquifer is approximately 29,728 acre feet per year.
How did you calculate that?
It is a combination of future use, non-irrigation use, irrigation use, and this application, if approved, assuming full volume.
So based on those calculations, is there available water to be appropriated?
There is a reasonable probability unappropriated water is available from the Dakota Aquifer for this proposed appropriation.
Can you tell me what the difference is between recharge and withdrawal to the aquifer?
Approximately 27,000 acre feet per year of recharge.
So that's 27,000 in excess?
Correct.
Did you also review observation wells in determining if there's available water?
I did.
How many observation wells are associated with this aquifer?
The Danner Water Rights Program monitors 46 wells completed into the Dakota Aquifer.
How many wells did you review?
I review all of them. I have to look at all of them when looking at the aquifer. But we also look at the 3 closest observation wells, closest to the applicant, the well the applicant provided as a well completion report. Those are ED-85A, which is approximately 34 miles east, HD-87A, approximately 76 miles southeast, and AU-89A, approximately 126 miles southwest.
All right, so I'm now looking at figure 1 in your report on page 7. I believe you said ED-85A is the closest observation well. Can you describe that trend line?
I would consider that to be a stable trend line.
Can you now describe the two trend lines for the other wells, AU-89A and HD-87A?
I would say they would be slightly declining.
So you mentioned earlier the presence of uncontrolled flowing wells. Do those wells influence the way you view the observation well data?
Yes, they do.
And how does the presence of those flowing wells influence the way you view the data?
The presence of the uncontrolled flowing wells in this case, these declining levels could be shown there just to say that the aquifer itself is trying to reach an equilibrium. The uncontrolled flowing wells in it might try to be just reaching down to an equilibrium point. Sorry for the repetition.
So when you see the downward trends on the hydrograph in figure 1 on page 7 of your report, do the downward trends worry you at all?
No.
Because of the presence of the flowing wells?
Yes, exactly.
So ultimately, what is the observation well data telling you about the probability of unappropriated water?
I'd say there's a reasonable probability unappropriated water is available for the proposed appropriation.
And so you mentioned that you also review the potential for unlawful impairment. How did you do that in this case?
We look at the closest water rights and permits, nearby domestic wells, and complaints for adequate wells within the Dakota Aquifer. The closest Dakota Aquifer water right permit not held by the applicant to the proposed diversion points is water permit number 8666-3, which is held by the SFP LLC. The diversion point for water permit number 8666-3 is located approximately 8.8 miles east of the diversion points for this application.
Are there also domestic wells in the area?
Yes, there are.
Do you review all domestic wells in the area?
No, it has not always been the case where it was necessary to submit a well completion report with an application.
So you're saying you don't have all domestic wells on file because some of them predate reporting requirements?
Correct.
What is the nearest domestic well that you have on file?
The closest domestic wells on file not held by the applicant are located approximately 3.8 miles to the southeast and 5.7 miles to the northeast of the proposed diversion points.
What are the requirements for a well to receive protection from unlawful impairment?
It has to be an adequate well.
What does it mean for a well to be adequate?
A well in which the pump intake was set at least 20 feet below the top of aquifer at the time of construction, or if the aquifer is less than 20 feet thick, is as near to the bottom of the aquifer as is practical.
Overall, what's your opinion on the potential for unlawful impairment?
Given the saturated thickness of the Dakota Aquifer in Edmonds County and the lack of substantiated well interference complaints for adequate wells into the Dakota Aquifer in Edmonds County or the surrounding counties.
Given the saturated thickness of the Dakota Aquifer in Edmonds County and the lack of
substantiated well interference complaints for adequate wells completed into the Dakota Aquifer in Edmonds County or the surrounding counties, any drawdown created from the proposed diversion is not expected to cause an unlawful impairment to existing water right permit holders or domestic users with adequate wells.
Did you review the petitions in this case?
Yes.
And after reviewing the concerns in those petitions, does it change your opinion on the availability of water and the potential for unlawful impairment?
No.
I have no further questions.
Thank you, Mr. Chair. Mr. Senchi, I'm curious about the general approach to your calculations.
as you consider withdrawals, is your analysis, over or generally underestimate withdrawals?
I would say we try to be conservative.
And what does that mean?
Over or under, we try to be, I guess, under would be conservative.
So on the withdrawals, does your calculation assume?
Excuse me, yes, we try to be what the most could be of that situation, so high. We try to think that the withdrawals would be on the higher side.
Thank you. So
Yes.
to be clear, your withdrawal calculation is using larger numbers than may actually be used, is that correct?
Yes.
Okay. And on the recharge, how would you describe your general approach to your calculations in this study?
Again, we try to be conservative with it, so whatever the most realistic number would be. So I'd say the conservative, the lower number of it, so.
As it relates to complaints on file, you use some qualifying language with respect to complaints. Are there complaints that your office has received for non-adequate wells, or are there no complaints that you've received in Edmonds County?
I would not be able to recall all the complaints for the Dakota Aquifer in this region. I primarily was just looking at ones that for adequate wells and that were investigated at the time. And I did not see any for an adequate well that would consider to be an adequate complaint.
So there may be people who would subjectively or have actually experienced a challenge with water access with their domestic well, correct? People may have complaints or have experienced problems.
Yes.
But whether or not that complaint related to an adequate well would be analyzed by your office, correct?
Yeah, correct. We look at all complaints.
And the complaint data that you analyzed, you've concluded in your report that there are no complaints on file with the Water Rights Program regarding well interference for adequate wells completed into the Dakota Aquifer, correct?
Correct.
I'm a bit curious about the review process. You clearly have an appropriate education, but I'm curious what some of the experience may be of others in your office who you have the benefit of those years of experience in reviewing your work. Can you provide me and the board with some information around who some of your colleagues are that reviewed this report in particular?
Right, so some of my co-engineers, Tyler Jensen, Kim Drennan, Whitney, sorry, I'm kind of spacing around, I was just out of nerves, but a good chunk of engineers ranging from engineer 1 to engineer 3 will all do an initial review of the application. These will be people who've also had experience in writing reports specific to the Dakota Aquifer, and they'll be able to look at any consistencies in my writing and double check, also including, besides just the technical, maybe spelling or just typos.
So, though the report has your name on it and you're here testifying today, the public of South Dakota and my client and the petitioners and the board before us have the benefit of not just your experience, but the years of experience of other staff as we review the report that you prepared. Is that correct?
Yes.
Circling back to your analysis, I'm curious if you can give me a bit more explanation around the hydrological budget and what that means and what that calculation is.
So specifically, we were looking at discharge, which takes into account everyone who's actively taking out water from the aquifer, and then the recharge based off of the best available studies that we have, give us the most accurate recharge amount that we can have. So based off of the recharge coming into the aquifer and the the totality of all withdrawals being taken from the aquifer are balanced, and from that, we are able to determine if the aquifer has available water in storage.
Those are all the questions I have for you this time. Thank you.
Thank you.
Any cross?
Yes, Mr. Chair. Good afternoon, Mr. Secchi.
Oh.
Mr. Secchi, your highest degree is a bachelor's in industrial engineering and engineering management from South Dakota School of Mines. Is that correct?
Yes.
And you graduated in December 22?
Correct.
And you were hired by the department in May of 24, correct?
Correct.
What did you do in between the 2 years, or a year and a half?
In between the 2 years, I had an opportunity to be a sound engineer. So I did a little bit of traveling. I got to go see around the country. And I helped manage a tour for a band called Blacklight District. During that time, I was the one overseeing and managing all these events, making things are going well. And then at the show, making sure audio was set up and that everything was sounding good. The overall term is usually called like a sound engineer. It doesn't have any real like engineering background compared to my degree.
Do you currently hold a professional engineer's license?
I do not.
Do you hold a professional geologist license?
I do not.
Did your coursework in college include any coursework on groundwater hydrogeology?
Hydrogeology? No hydrogeology courses. I did take classes in geology though.
So you're the author of what's being introduced today as the Secchi report in application 8991-3, correct?
Correct.
In your recharge analysis, is it fair that it primarily relies on the Bredenhoft 1983 study?
Yes.
And you characterize that 3 times throughout your report as outdated, is that correct?
Oh, yes, it is listed as outdated in the report.
And did you ever commission or perform an updated recharge study?
I have not done an updated recharge study from this report, no.
So I'm admittedly not an engineer. We'll back up. What would that look like?
If there were new documents, new research that went into it, we take the most up-to-date information available, and then we have to readjust our values of what that recharge value would be, and then compare that to the withdrawals. So if the newer studies were to say that there was more water available, then that number would be higher.
And when you say new studies, who's performing those? Does Daner perform those?
No, there's studies performed by STGS, USGS. I would say those are probably the most common.
I'd like to turn your attention to page 3 of your report, Mr. Secchi. And I'm 2 lines above the indentation of discharge. It's the first paragraph, it's not a full paragraph, but I'm gonna read it. And you wrote, "It is unknown whether the true recharge rate of the Dakota aquifer is higher or lower than Bredenhoft and others, parenthetical 1983, close parenthetical estimates." Do you see that?
Yes, I do.
And did I read that correctly?
Yeah, approximately.
And so at the time you wrote your report, you didn't know the exact amount for the recharge rate. Is that accurate based on that sentence that I just read?
We used the best available information at the time.
But at the time, the Bredenhoft, or apologies if I'm mispronouncing that, the Bredenhoft was outdated, as you said.
Yes.
But that's what you used?
Correct.
Did you look for other studies that may have been done on the Dakota aquifer to give us a more present day recharge rate?
I looked at all available information that was published at the time.
And so I apologize if I'm asking this again, but what would it look like for you to conduct what Bredenhoft did in 1983 today?
Well, what Bredenhoff does and what I do are separate things. He would have a much stronger foundation in hydrology to be able to determine exactly how water is being able to move through these formations and be able to determine things such as recharge rate through certain aquifers and how those materials affect the transmissivity of that material. I look at what is available and then I write my study on a comparing basis between that recharge and the withdrawal.
And your recharge rate, it could be higher or it could be lower based on what Bredenhoff gave us 23 years, or 43 years ago, excuse me.
In the report, it says it can be higher or it can be lower.
And that's your testimony today?
I think more recent studies show that actually more recharge could be available.
So it would lean more, would you amend your report in any way to reflect only higher recharge analysis?
So if I had the report that it came out after this, would I amend it to be to the most up-to-date factual information?
I guess my question's a little more pointed. It's stated in your report that the actual recharge rate could be higher or it could be lower.
Right.
And I want to make sure that's your testimony as we sit here today.
Yes.
That it could be higher or lower than the Bredenhoff study of 1983.
Yes.
And on page 6 of your report, I'll let you turn there. And I'm about the 4th line up, you write, "It is currently unknown how much water is being discharged from the Dakota Aquifer through uncontrolled flowing wells." What did you mean when you wrote that?
Currently don't have a way to measure how much water is being lost to uncontrolled flowing wells in the Dakota.
So backing up to elementary principles here, that refers to withdrawals versus recharge, correct?
I would not say that an uncontrolled flowing well is necessarily withdrawing from it. It's a natural process that is happening within the aquifer as it's trying to reach equilibrium. The pressure of the Dakota aquifer is what is causing the water to be pushed up through the ground and then expelled on the surface.
Your statement here, though, does that affect withdrawal at all, or no?
I would say it affects the way that we look at the observation wells, which is something that we definitely consider in our report. As stated earlier, that some show a slight decline, while the one closest to this application is stable. It could just show that the uncontrolled flowing wells in those areas are associated with the slight decline.
And those ones didn't include domestic wells that predate a certain time period, is that correct?
Yes, that's correct.
So there could be domestic wells closer to the applicant's proposed well in 89913 that weren't in consideration in this report, is that correct?
It's possible.
When you wrote, still on page 6, that the Bredenhoff and others 1983 recharge estimate relies on outdated assumptions, what did you mean by outdated assumptions? Did that have to do more with methodology, or was that just Bredenhoff's analysis was solid, but it's 43 years ago, so the time of history may not, right? It's not updated on a contemporary sense.
Right. It'd be outdated, right? So the newer information that'd be coming in could change that amount.
And that includes the methodologies that Bredenhoff uses, or used in 1983?
I'm not extremely knowledgeable on every method that Bredenhoff had used to come up with this estimate, but I do know that this is the most accurate information we have at the time to be able to use in this report.
Does your recharge estimate have a margin of error?
It is labeled as approximately. I would not be able to tell you what the margin of error is. I'd say it's as accurate as possible based off the given information I had to work with.
When you write a report, Mr. Setji, do you include irrigation, livestock, municipal, and water usage in that cumulative analysis?
Yes, the estimate includes future use, non-irrigation, irrigation, in this application.
I also saw that there were a few conditions on page 1 of your report, if we can turn back to that. And I apologize, that's in the recommendation of acting chief engineer for water permit. What's your role in the numbered qualifications that are listed on that cover page that we have here, 1 through 7?
You know, I do apologize, I don't have that in front of me right now.
Oh, I have a copy if that's okay. May I approach, Mr. Chair?
Can you redirect? Oh, yeah, you may.
Could you repeat the question?
Sure thing. What role do you play in the qualifications that are listed in the engineer's ultimate report and recommendation, those 7 qualifications that are listed for 89913? Do you recommend to your chief engineer a recommendation?
Yes, the technical report is for the chief engineer to be able to make recommendations and write up this.
Do you see that before it goes out? Does he come back to you or she come back to you and ask, hey, here's my ultimate recommendation, do you approve of this based on your technical report?
No.
So did you see the 7 qualifications prior to, I guess, right now?
No.
Stepping back in a little framework for me, when the Water Rights Program receives an application from an applicant, how is that process, how is it divvied out, I guess? Who determines who gets what applicant, what engineer level gets what application to review? Does it depend on depth or the amount of water that's being proposed in the application? Or how does it go to an engineer 1 versus an engineer 4? I apologize for the long-winded question.
You are fine. That'd be a question for the chief engineer.
You just know when you get a report that you have, or an application that you have to write a report for?
Correct.
I have no further questions at this time, Mr. Chair. Thank you.
Thank you.
Thank you.
Yes. Austin, about how many reports have you authored?
Today, probably around 40.
Did you say 40, 40?
40, correct.
Okay. Do you know if you've completed other reports regarding the Dakota Aquifer?
I have.
Do you know how many?
I'm gonna kind of guess here. I'm gonna say 4 to 5.
And then, do you remember if those water rights were ultimately granted?
I believe so.
And so, there was a couple of questions on Cross about recharge studies. Do you as a staff engineer conduct recharge studies?
No.
Do your co-engineers conduct recharge studies?
No.
Do you know how long it would take, or what does a recharge study entail?
I'm sure they look at every single characteristics of that given area of that aquifer. So they'll have to look at the geological characteristics of the aquifer, recorded data from precipitation in the area, a level of UV from the sun dealing with evaporation in the area, stream level gauging, etc. My knowledge of it's not a lot.
And then you had mentioned earlier that one of the ways the Dakota Aquifer receives recharge is through infiltration from other aquifers.
Yes.
Do you know which aquifers put water into the Dakota?
The Madison and the Indian Cara.
And you did notice in your review, and this is on page 3 of your report, that there are updated studies to the Madison and the Indian Kara aquifers.
Yes.
And those reviews actually suggested higher recharge to those aquifers.
Correct.
And so the aquifers that are recharging the Dakota aquifer have a substantial number or a substantial amount of recharge?
Yes.
And then you did mention because Bredehoff is somewhat outdated, you can't accurately say whether the recharge today is higher or lower.
Correct.
Based on your experience, do you think that number would be higher or lower than the 27,000 in excess?
I think it could be.
You think it could be?
Yes. Higher. There, I believe there could.
I guess what I'm saying is, would it deviate that much? If it was higher or lower, would you expect to have more lower recharge than there is withdrawals? Is that a possibility?
No.
Those are all the questions I have.
You were asked to analyze whether there's a reasonable probability that there is unappropriated water available for the applicant's proposed use, correct?
Correct.
And you concluded that there's at least approximately 27,000 acre per foot, correct? Excuse me, I've got the.
Yeah, no, acre feet per year.
Yes, thank you. That's correct?
Yes.
Likewise, you were asked to analyze whether or not the proposed diversion can be developed without unlawful impairment of existing domestic water uses and water rights, and you've concluded that it can be?
Correct.
No further questions.
Anyone across?
Very briefly, Mr. Chair, if that's okay. Mr. Setchi, you testified that you have authored about 40 or so reports since your tenure at the water program. Is that correct?
Correct.
Do you recall any of those being challenged for your failing to find a recharge rate?
What do you mean by challenged?
Do you recall any petitions or comments or contested case hearings in which you were the author of a report such as this when or where someone challenged the recharge rate like petitioners are challenging in this case?
I wouldn't be able to recall off the top of my head.
Do you recall in the Dakota Aquifer cases, the 4 or 5 reports that you did, whether you used the same reports that you used in this report? The same studies that you used in this report?
Could you just phrase that question a little differently for me?
Sure. In the past reports that you've done that have involved the Dakota Aquifer, I think you testified you've done approximately 4 to 5. In those reports, did you use the same studies to calculate the recharge rate as you did in this case?
Yes.
Did you use the same outdated language, or did you use the same outdated adjectives to describe the Bredenhoff studies in those reports, if you recall?
I don't recall if the same language was used throughout all of them. I do know it was used in this one. And I'm also not sure if it was specific to just this report.
That's all the questions I have, Mr. Chair.
Thank you. Any questions from the board? So the recharge data you were looking at, that you said it's outdated, right?
Correct.
And that was a study was from 1909.
Bredenhoff is 1983.
And was there another one, older one you referred to in your report?
Let me see date-wise here. Brennenhoff and others attempted to match Darden's 1909. So Darden had done, I think, the original study in the Dakota Aquifer, and Brennenhoff, as far as I understand, wants to be able to at least replicate some of those parts and probably be able to build off of Darden's work. Or, yeah, Darden's work.
But as you concede in your report, you don't know what this recharge rate is, correct?
I don't know the exact amount. I just tried to use what was the most accurate that we have at the time, which is Brennenhoff's.
I don't expect you to give the exact amount, but I read your report, it didn't really tell us exact or anything even close. You say 57,000, but I don't see where you refer to any study that says that.
That was taken directly from Brennenhoff's study.
From 1983, that's outdated.
Correct.
Okay. So the recharge could be much less, it could be much more, but you can't tell us for here today what it is. Within a reasonable degree of certainty, right?
I would say this is close. I would say any further study coming after this would be close to these numbers.
Thank you.
Yeah.
Any other witnesses, Ms. Greco?
Yes, I would call Adam Mathewitz. And can you state and spell your name for the record?
Adam Mathewitz, Mathiowetz.
And I'll hand you what's been marked as Exhibit 3. Can you tell me what that is?
That is my curriculum vitae.
Did you produce or make that document?
Yes.
And is it accurate and up to date?
Yes.
I move to admit Exhibit 3.
No objection.
No objection. Or, excuse me, it's admitted. Sorry.
Can you describe your educational background?
I hold a bachelor's and master's of science in agricultural and biosystems engineering from South Dakota State University.
Do you have any professional licenses?
Yes, I am a licensed professional engineer in the state of South Dakota.
And what is your current position with the department?
I am the acting chief engineer of the water rights program.
How long have you been in this position?
3 months,
How long have you been with the water rights program?
14 years.
What did you do before you were chief engineer?
I served as a engineer 4, was my last position. I was our groundwater expert. And in that role, I managed our observation well network, reviewed well construction for well completion reports, reviewed water permit applications, as well as assisted the chief engineer in assigning them to staff members, and other groundwater related activities, including technical assistance and other groundwater related activities.
Would you be able to approximate the amount of reports you've authored yourself?
More than 200.
Would you be able to approximate the amount of reports you've reviewed for others?
Probably just about as many.
What do you do now as the chief engineer for the program?
As the chief engineer, I am the program administrator, directly under the direction of Office of Water Director Mark Mayer. I am the administrator of our state dam safety program. I manage the tasks and assignment of duties to our staff members, which includes assigning applications for technical review, as well as making recommendations on those applications. And I provide technical assistance to the Water Management Board, members of the public, and state and federal agencies.
What is your general understanding of how a water permit application moves through this process?
The basic process of a water permit application is an application is submitted, and once it is deemed complete, it is assigned or given to me to assign to an engineer for a technical review. Frequently during that time, I also assess which water source to assist myself in assigning those. The technical engineer will do a review regarding unappropriated the availability of unappropriated water, and the potential for unlawful impairment. Then the review is given, or the report is given to all the other technical engineers for a peer review to look for both the technical issues or grammar and spelling issues and review to make sure everything that should be considered was. Then after those corrections are made, it is provided to the administrative staff within the program. We again, and that includes me, conduct a review to again look for technical, grammar, legal issues within that. Upon completion of that review and finalization of the report, the chief engineer makes a recommendation. That recommendation is noticed in newspapers, as well as on the DANR contested case public notice webpage. For the newspapers, it is placed in the newspaper of the county, the newspaper of record for the county where the permit is and water use is to be. If that is not a daily newspaper, it is also listed in the nearest daily newspaper. Then it is allowed during that time for comment and petition and intervention by members of the public, or if the recommendation is one the applicant themselves disagree with, for the applicant as well. Then depending on the outcome of that, if it were, for example, an approval recommendation and there was no petitions or contestation from the public, then we as the Water Rights Program can administratively approve it on behalf of the Water Management Board. Most other instances, if there is any intervention from the public, or if it were, say, for example, a deferral recommendation, then it is brought to the Water Management Board for hearing.
And are you familiar with application number 8991-3?
Yes, I am.
What was your involvement with this application?
Originally, I reviewed it and then assigned it to Austin to write the technical report, as well as during his writing of technical report, I assisted him as needed in understanding or processing information. Then I peer reviewed it as one of the technical engineering staff. And then when it was sent for admin review, I also review the administrative review, simply because I want to make sure any language that they change for maybe grammar or legal purposes doesn't affect any technical meanings. And that's my role with the report.
And so you didn't write the recommendation of this report?
I did not.
Do you agree with the recommendation of the previous acting chief engineer, Mark Mayer?
I do.
And can you tell the board what that recommendation is?
The recommendation was for approval with qualifications.
And just generally, what are those qualifications?
There are 7 qualifications. First one is our standard well interference qualification. It states that the wells proposed to be used by this application are located near domestic wells and other wells which may obtain water from the same aquifer. The well owner must control their withdrawals such that there is not a reduction of needed water supplies in adequate domestic wells or in adequate wells having prior water rights. The proposed wells, this is number 2, must be constructed by a licensed well driller, and the construction of the well and installation of the pump must comply with Water Management Board well construction standards, and the well casing must be pressure guarded bottom to top pursuant to specific rule within there. The third qualification, the proposed new wells and any future replacement wells must meet the adequate well construction standard as defined in well construction standards, and those new wells and any replacement wells cannot use the alternative Dakota well construction standard, specifically 74:02:04:35, which is also more commonly known as a slim hole well, due to limitations of that construction methodology, as well as other rules requiring permitted new construction, new wells for permitted appropriations to meet the adequate well definition. Number 4, it is the application permit is subject to compliance with the department's water pollution control permits issued per the codified laws stated there for concentrated animal feeding operations. Qualification number 5, permit is subject to compliance with all existing and applicable Water Management Board rules, including but not limited to groundwater quality standards, groundwater discharge permit, surface water quality standards, uses assigned to lakes, uses assigned to streams, and surface water discharge provisions. Number 6, The permit holder must report their annual amount withdrawn from the Dakota Aquifer to the chief engineer. And number 7, this is, permit would authorize a total annual diversion of up to 154 acre-feet of water annually from the Dakota Aquifer.
So just to confirm, the recommendation accurately reflects your position.
Yes.
Can you tell the board how this application is for a beneficial use?
Commercial use in an animal feeding operation is for an ag purpose. We are an ag state, and as statutorily required, we are to place the water resources of the state to the maximum beneficial use that is they can handle.
Can you also tell the board how this permit would be in the public interest?
Putting water to beneficial use to feed livestock, creates economic value as well as provides, livestock opportunity. So therefore, that would also be in the public interest.
We heard Austin talk about uncontrolled flowing wells. What happens to the water that's flowing out of these wells?
So an uncontrolled flowing well, as Austin stated, is a well that is flowing at land surface. The uncontrolled part means whether it has no valving or control structure, or it could be even broken below ground and having underground flow as well, and that it is not managed. So therefore, the water that is flowing to waste, and not, some of it may be used, but not all of it.
What is the program's position as it relates to uncontrolled flowing wells?
The program's position is based off of previous Water Management Board position that uncontrolled flowing wells that are flowing to waste, that water can be appropriated because it does not constitute an appropriative withdrawal.
So what you're saying is it would be better to appropriate this water for a beneficial use before it's able to flow out of an uncontrolled flowing well?
Correct.
And how does the appropriation prevent the uncontrolled flowing well?
So an uncontrolled flowing well is reliant on having head pressure above land surface, and that means when you drill a well into the aquifer, that's the water level as it rises above the top of the aquifer. And if you are placing water to use, there is always going to be some drawdown. That's the physics of how wells work. And thereby, if you are placing it to use, you are reducing what could be flowing to waste.
Are you familiar with recharge studies?
I have some familiarity, yes.
Have you conducted recharge studies?
I have not conducted any myself, no.
Has the department conducted recharge studies to your knowledge?
The water rights program has not. I do believe the South Dakota Geologic Survey, which is part of the Department of Agriculture and Natural Resources, has done some.
What is required for a recharge study?
Some of that depends on the specific aquifer. In general, you're going to look at the geology, and that's going to include drilling holes and reviewing of what holes have already been drilled. You're going to look at the hydrology, so you're going to consider water levels, whether that is in existing wells or in observation wells that are new. You're also going to look at your recharge sources and how that recharge mechanism occurs, which is going to involve precipitation, infiltration rates if it's a shallower aquifer that does rely more on direct infiltration from precip on the land surface versus on a recharge zone, as well as evaporation and other types of methodologies that prevent some of that precipitation from entering the aquifer.
And how long would one of these studies take?
Again, it depends on the scale. I don't know, a relatively small aquifer, say maybe 20, 30 square miles, That could be a few years, something such as the Dakota that covers the entire state. If you were to do a less detailed study, again, 5, maybe 10 years, a highly detailed study could take 20 years.
So the engineers in the program are left with reviewing the studies that have been completed. Otherwise, wait for a study to be completed.
Yes.
And what is your opinion as to the status of the Breda Hoff report?
So I think some of the discussion was not necessarily as clear as written in the report by Austin. It is, with Breda Hoff, there are certain data points used in the estimation that we know are outdated. In particular, it was the incoming recharge from the Madison and the Indian Cara. There was a 2025 study that was completed that indicated more recharge goes into those aquifers. Therefore, there would be greater potential for that recharge to get into the Dakota aquifer. In its general status, the methodologies and other numbers are relatively good, and they're going to be, carry forward and is the best reasonably available information, which is what we are charged to use.
And so, if there was, say, a range above or below that 27,000, would you be able to approximate what that range would look like?
I would expect the range at this time to lean slightly higher. To put a number on it, I would not expect a plus or minus more than 5,000 acre feet, based on my experience looking at other studies that have been conducted for multiple aquifers. Because usually you're looking at a percentage variance, and usually that is related to either the quality of methodology to equations, because back in the day you used pencil and paper and maybe a calculator, and today we have high-powered computers that can handle a lot more involved equations. So the methodology is the same, the ability to process extra, and so you have, that adds a variation as well as changing precipitation, and also the availability of that precipitation data. We have, from 1983, we now have 42 more years of precipitation data. So that would also inherently affect that calculation.
All right, so your testimony here is today is that number might deviate by approximately 5,000, plus or minus?
I would expect it to be within that range.
Is it possible that it would deviate as much as 27,000?
I would not expect that.
Did you review the petitions in this case?
Yes, I did.
All right, I think we've talked about this a lot at this point, but one of the main concerns was about the sufficiency of the data. How would you respond to that?
Again, when we look at the withdrawals portion, we use the data that we have, which is the appropriative permits, and those that report, we use their numbers. We use permitted volumes, and our estimation method that we have used, which is for those that do neither, the 60% methodology has shown that when we compare that to many other types of use, that is reasonable, and that number has been accepted multiple times throughout the history of the Water Management Board. When it comes to recharge, again, best reasonably available information is what we are charged to use, and Breda Hoff is that, but also even when taking in the fact that there is new data for some portions of their methodology, that new data indicates that that recharge number is probably on the low side.
Another one of the concerns regarded the entire impact of Century Swine's operation. How would you respond to that concern?
So there are two applications, both of which are being heard here today. They are for two aquifers that are separate. They're separate aquifers. They are very hydrologically distinct with several hundred feet in between them, most of which is confining layers, hydrologically separating them.
Another one of the concerns in the petition was that Century Swine was asking for more water than what they might actually ultimately use. How do you respond to that?
We do not set the number of what the applicant's request is. We do offer advice if they have questions, and we generally say, or suggest that if they are uncertain, to apply for a bit more than they think they'll need, because when we go to do a licensing inspection, we can inspect that and license it down to what's built. If they overbuild, then they have to come and get a new permit.
And so when they ultimately get the license, they're licensed for the amount that they use, that they put to beneficial use.
They are licensed for their as-built, so what they put in place for construction and as used. As long as both are within their permit. If there are deviations, then they are required, that are outside the permit, then required to get a new permit.
After reviewing the petitions, are you concerned about the recommendation?
No, I am not.
That's all the questions I have.
Mr. Shitter?
Thank you, Mr. Chair. Just a couple of quick questions. With respect to the rechargeability, we're talking about a magnitude of 27,000 acre feet annually, correct? We believe is the delta between the recharge and the withdrawals.
I believe that's approximately correct.
And with respect to this application, what is the volume of water being sought?
The applicant applied for, I believe, is 154 acre feet per year.
With respect to other hog facilities that you have experience with the Water Management Board, what has this body found with respect to the public benefit?
As far as I'm aware, in general, the Water Rights Program in its past and the Water Management Board has found that placing water to use to provide water to hogs is a beneficial use of water.
And same question with respect to public interest.
In general, I believe the past of both the Water Rights Program and the Water Management Board has found that placing water to beneficial use in a commercial operation to feed swine is in the public interest.
Mr. Chair, I don't have any further questions.
Cross from the petitioner.
Thank you, Mr. Chair. Mr. Mathiowicz, am I pronouncing that correctly?
Mathowitz.
Mathowitz? Is that better?
Yes, sir.
Mr. Mathowitz, you did not author the report that Mr. Setji authored or wrote that we're looking at in this application, is that correct?
I assisted as needed. I believe I am signed as a reviewer.
Did you, or do you recall the outdated language that we talked about earlier?
I do.
And do you recall that the report doesn't just use the probability of the recharge rate being higher, it also uses the equal probability of it being lower, correct?
It does not mention whether they are equal, it just mentions that it could be either.
And the report also doesn't include what I'm calling a margin of error, or the 5,000 number that you testified to that it could be higher or lower. The report doesn't say that, right?
No, it does not.
Does the report discuss the public interest or benefit that you talked about here today?
That is outside the scope of the report.
Do you know if the report or if the permit was to violate a county ordinance would that constitute harm to the public interest where that prong would not be satisfied?
Please restate the question.
Sure, so under 46-2A9, there's the 4 prongs that's required for a permit to be issued, correct?
Correct.
And one of those prongs is the public interest, correct?
Correct.
If the permit is granted in violation of an Edmonds County ordinance, would that be a problem for the public interest prong?
To clarify, are you talking an existing ordinance or an future ordinance?
An existing one today.
Potentially.
What do you mean potentially?
It depends on the nature of the ordinance.
If the ordinance were to require the CAFO to be viewed as 1 and Dana viewed them as 2, would that be a problem to the public interest in your view?
Do you mean the CAFO or the water supply to the CAFO?
The water supply to the CAFO. Thank you for that correction.
To me, no, because the water supplies are distinct from each other and therefore you have to consider them independently.
So you don't have to consider the cumulative impact? I'm sorry, go ahead. I interrupted you, go ahead, sorry.
Each application is for an independent water source, as we have to manage the water sources independently of each other. We review a hydrologic budget, we review observation wells. An observation well cannot measure 2 aquifers.
The observation well cannot measure 2 aquifers.
That's where I stop. Okay. Therefore, the technical review, which is the report, needs to only be able to consider that one. And that's why when you have multiple applications for one facility but with different water sources, there are 2 applications and 2 reports, and thus 2 recommendations. The recommendation is based off of the application.
But for the public interest prong of it, isn't it the same public interest or the same proposed use, the beneficial use, isn't it the same one regardless of the water source? Do we need to look at that cumulatively?
Not necessarily, because if you have a well in one aquifer and not in the other, you would not necessarily have an interest in the second aquifer.
If the same purported use, though, for both aquifers was going back to the same purported beneficial use, would you consider that in your 4-prong analysis?
Please state the question again.
Sure. So in the 4-prong analysis, there's the beneficial use aspect, correct?
Correct.
Isn't the beneficial use the same for 2 wells that are supplying water to a commercial operation?
Correct.
Then what's the distinction between the beneficial use analysis that we're doing?
So the beneficial use is the type of use, how the water is being placed to use. And the user is the same, but again, it's a separate application for a separate water source, so they are considered separately. While the consideration for all practical purpose on the beneficial use is the same. They are in fact still separate.
But I believe you testified earlier that this report that we're looking at here for 89913 does not address either the beneficial use or the matters of the public interest. Is that correct?
The technical reports, and as they state within the report, themselves address specifically the availability of unappropriated water and the potential for unlawful impairment.
Are you aware of any authority that would require you to conduct a recharge study?
No.
Your Honor, may I approach?
You may.
I'm sorry, Mr. Chair, may I approach?
Okay.
I've just handed you what's been previously marked as Exhibit 201 from the petitioners. And I can represent to you that this is a letter that was written or authored by, turn to page 16, I believe. Apologies. Top of 15, a Circuit Court Judge, Sean M. O'Brien. Do you see that, sir?
Yes.
And I want to draw your attention to page 12 of this letter. And excluding the footnote, I'm going to start at 4 lines up from the top that starts, "It seems contradictory to assert that it is not probable that the water withdrawn annually will exceed the average annual recharge without ever calculating the annual recharge or the average annual recharge." Do you see that?
No, I did not find where you were mentioning.
I apologize. We're on page 12.
I am on page 12.
Okay. And then excluding the footnote, we're 4 lines up from the bottom.
Oh, I thought you said 4 from the top.
I apologize, I probably did. I can reread that if you'd like, but it's a sentence that starts out, "It seems contradictory to assert."
Please read it again.
Sure. "It seems contradictory to assert that it is not probable that the water withdrawn annually will exceed the average annual recharge without ever calculating the annual recharge or the average annual recharge." Do you see that, sir?
Yes.
Do you agree with that statement?
Yes.
Do you agree here that a recharge study could theoretically be done on the Dakota Aquifer today?
Yes.
Mr. Chair, I'd like to move to admit Exhibit 201.
Any objections?
No objection.
No objection.
201 is admitted.
If I may approach, Mr. Chair.
Yes, you may.
Thank you. Sorry. Sir, I've just handed you what's been previously marked as Exhibit 202, and I can represent that this was a corresponding filing in the same case that we looked at, or that was addressed in Exhibit 201. This is an order having issued its findings of fact and conclusions of law that the water permit previously granted, it's the same water permit that was discussed in Exhibit 201, was reversed and remanded back for further proceedings consistent with the court's decision, which I believe is accurately reflected in the letter of Exhibit 201. Do you see that?
Yes.
Your Honor, I'd like to move, Mr. Chairman, I'd like to move to admit Exhibit 202.
Objection, Ms. Burke.
No objection.
Mr. Shep.
No objection.
Exhibit 202 is admitted.
Switching gears a little bit, do you know what a cone of depression is?
Yes.
Can you please explain to me what that is?
A cone of depression is the drawdown immediately around a pumping well.
Do you know if any cone of depression studies were done in this report?
Do not believe so.
Do you know why not?
No. I would actually like to correct myself, if I may.
Of course.
Typically, that is not standard practice of the water rights program when we do not have high-quality local data on transmissivity. And when I say high quality, I mean extensive study. Unless we have a significant amount of lower quality local data.
Can you please explain what the static water rate is? What it is in general?
Do you mean static water level?
Yes, thank you for that correction.
Static water level is the water level of an aquifer under what is called static conditions, which is its standard non-pumped condition.
And do you know what that static water level was here?
Not off the top of my head. I believe it is in the report.
We can pull it up real quick. I believe it's 180, but I'll turn to a page real quick. Looks like it's on the first page of Mr. Setch's report. And it's the sentence begins the third line up from the bottom. Do you see that, sir?
I don't have a copy of the report.
Oh.
Static water level on the well, as it was drilled on November 10th, 2025, was 180 feet below ground surface.
Does that level seem, thank you, does that level seem unusually low to you?
No.
Did the program conduct any study that reflects an average of the static water level in this area?
Part of the review of potential for unlawful impairment, as well as the mentions on one of the tables of Mr. Setch's in his report referencing historic water levels, does include review of that.
Do you have any explanation for why the static water level for this permit would be substantially lower than the average in the area?
Can you define substantially, please?
180 feet compared to 80 feet on average.
So some of that depends on exactly when it's time of year drilled. Some of that depends on, did the driller wait sufficiently long enough for full recovery in the well, and measuring it an hour after the air developed it versus 48 hours, versus 76 hours, versus 3 weeks. Because some wells in their immediate area recover much faster than others. We see that with our own observation well network when we maintain it. Some of that could be also based on date. When was it, what was the date of the others? You know, a wetter year, you have higher water levels.
In what year?
A wetter year, but also time of year. Primary recharge here in South Dakota is spring and late winter through early summer. A later year reading and measurement is typically going to be lower than a spring reading in the same year. Now you will have some inversions of that, especially with such as a very shallow aquifer. When you have a high precip year, you know, a later year might be higher than the spring year, but typically, in general, Your later year readings before the recharge season are lower than your earlier in year readings.
Do you know if when this report was done, it was dry or wet, as you characterized it in the explanation?
When the report was written,
Yes.
what is the completion date on the top of the report? On the first page.
January 27th, 2026.
I believe we have had drier conditions in the last half year.
So that would not result in, that wouldn't explain why the 180 would be substantially different than the 80 on average?
That would also add to that consideration. A drier condition does tend to lower water levels.
Do you know when the well was dug in this instance?
It was drilled in 2025, I believe. And to go back to the other question, the other thing to account for is topography. If it's, when we look at a lot of these, we look in terms of elevation of the water. So if you're not accounting for topography, that 80-foot water level and that 180-foot water level, once you account for elevation, could be the same.
How does the program analyze the domestic wells that aren't on record?
If we don't have an information to analyze, we can't analyze it.
How would you obtain that information if it's not recorded because it predates the recording requirements?
Someone would have to ask.
An owner of the well could tell you guys, or?
The owner could also provide that to you. You asked how we could obtain it. Someone would have to ask how it could be obtained in general. The owner would have to provide that information to us with enough information to substantiate what aquifer the well is in. They couldn't just say they have a well. They would need additional information to verify the water source of that well.
May I approach, Mr. Chair?
Yes, you may.
Last exhibit. Thank you. Declaration of Robin. Or her name there. Sorry. Okay. Have you ever seen exhibit? I apologize, my microphone died, but I've never been told I have a quiet voice, so I'll just keep going. But have you ever seen exhibit 204 before?
It seems familiar, but I can't say for certain if I have seen it before.
Is this the type of information that you, at the program, that you were discussing previously about owners of domestic wells not on record? How we discussed how you would obtain that information or how individuals would present it to you. Is this the type of information that the board would take into consideration? Excuse me, the program take into consideration?
I do believe some of it is in here in terms of well construction. I saw one mention of well depth, so that would be one factor. The personal history, which appears to be most of this, would not necessarily be relevant into determining the well, its water source, or its adequacy in terms of the adequate well rule.
Understood. And in the 4 factors that the program analyzes, a domestic well owner that doesn't show up on a recorded Daner process, this would be one avenue that they could submit information to you to show potential harm.
As part of a petition, this would be a reasonable form. I would like to note this well is not completed into the Dakota Aquifer, as listed in this document, based on depth alone. But this is one avenue. We actually do have a form available for registering your domestic well. And that would be because it doesn't have the extra text and context, so therefore it is easily determinable water source, as well as for ourselves in the program and any member of the public who may use our various databases.
Would the board would the program take into consideration the potential harm as part of the public interest prong to this well?
For the aquifer that it is completed into, yes, which is not the Dakota Aquifer, which this particular application is discussing.
And how do you know this particular well isn't in the Dakota Aquifer?
Item number 6 specifies that the well was drilled to a depth of 420 feet. The Dakota Aquifer in this area, as mentioned by Austin, is over 1,000 feet deep.
Would it be in a different aquifer then, if is it that simple that there's just a depth that you hit a certain aquifer and if you keep going lower you hit a different one?
In this location, it is, obviously there's some variation with topography. This is not like the Black Hills where there's hundreds of feet of topography over a quarter mile. There can be, but in general, there isn't. And this much difference in depth, yes, it is relatively that simple. There is more subtlety and complexity in geology, but broadly, yes.
Can you tell me what's above the Dakota Aquifer then, based on the 420 feet? If you know that that's not the Dakota Aquifer, can you tell us what aquifer it does go into?
So there are multiple formations above it. I would need a state geologic and stratigraphic map to give exact details. But based on the depth of that well, I believe it will either be into the Pierce Shale or potentially the Niobrara Formation. Obviously, having the well completion report with detailed geology would give me that answer. And furthermore, having, well, I guess the location as described of the well is on here, so that would also aid. But standing here, I could not give you a certainty of which.
Backing up, that's something that you would work together with, I'm not gonna call them a petitioner, but you would work with the submitter of this material. Would the program work with them to develop? I guess I'm just taking a step back from a practical standpoint. If I own a domestic well and I'm worried that a potential new well will impact it, how do I tell the program about this existing well?
So there are several avenues. If it were, say, just in general, you're concerned about rumor, so therefore there is no contested case, contacting us. And then we would work through the process to register, or at the very least, discuss with you what aquifer your well may be into compared to the rumor out there. In the case of the contested case, obviously that would be part of the petition process.
But Mr. Setchi's report that we looked at, he includes all impacted wells, not just those who petitioned or submitted or contacted the program. Is that correct?
Mr. Setchi reviewed the wells that he has information available to him.
And when you author reports like that, like Mr. Setchi, I don't want to get into what he did because of foundation issues, but when you author reports like that, you consider all wells that could be affected by the applicant's proposed well, regardless if those owners of the wells have contacted you. Is that correct?
If we have information on it and we determine that it's within the same aquifer, yes, we consider them.
I have no further questions at this time, Mr. Chair. Thank you.
Any redirect?
Yes, I do have some. So to start, is it typical for applicants and authorized users to be using water under multiple permits or multiple rights?
Yes, under multiple rights as well as potentially from multiple sources depending on their needs, quality, location, availability. Sometimes even just the cost to drill a deeper well may cause them to change water source to something that's a little less costly.
So it's not unusual that there are two applications to different sources in this case?
No, it is not unusual.
Would it be unusual for an applicant to have multiple rights for different sources as well as hook up to a local distribution system?
That would not be unusual, particularly with livestock operations. They really like to have backup sources, because, yeah.
And so I know we've talked about it a lot at this point, the Bredehoft study. Based on your experience, your knowledge and experience, how can you be confident that the recharge would still be greater than?
So the scale of difference between the estimated average annual withdrawals and the estimated recharge to begin with. Further, there is uncontrolled flowing wells, and there is some history. There have been estimates of there might be thousands of them without, there is, estimates by, previous water rights staff, but also others. I would not say there's been a study, I should correct myself on that. Which would then be based on previous discussion of that water's available for appropriation, further add to not recharge, but water available.
And so, ultimately, you are still confident that there's a reasonable probability that there's available water?
Yes, I am.
And in preparing for today, did you review the Hanson County application case file,
Yes, I did.
which included exhibits 201 and 202?
Correct.
So are you familiar with what a remand from circuit court is?
Not completely. To my understanding, it is, you have to review it again in light of input from the circuit court.
So this order in Exhibit 202 remanding to the Water Management Board was not a decision to deny the permit?
To my understanding, no.
Do you happen to know what the result of that review ended up in?
No, I do not.
Do you know if a final decision was entered?
Yes, the Water Management Board did enter a final decision. That is their standard practice, if it goes in front of them, so.
Are you sure that there was a final decision in this case?
I am not certain. As I tried to clarify at the end, if it goes back in front of them, there would be. I do not know if it got all the way back to the board. I do not remember if it was withdrawn by the applicant or not off the top of my head.
Would it help if you reviewed the case file for that application?
Yes.
Sorry, this is just gonna take a minute for me to pull it up. I can just use mine, thank you.
Yes.
Just take a break now. Let's take a short recess. It's 4:07. Come back at 4:15 or so. We'll get started. We're now in recess.
Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net.
Record and resume, Ms. Greco, your witness.
I think I had asked before the break, if it would help if you reviewed the Hanson County Dairy, application file, which is on file with the rights, understanding on that case.
Yes, sir.
May I approach?
Yes.
Can you review page 928 and 929 of this document?
Page 928 of the file for 7-2.
And you could just read it.
39, okay. Yep. So, it's a letter addressed to Eric Gronlund in the matter of water permit application number 7239-3, Hanson County Dairy, our file number 06-2042-3. Dear Mr. Gronlund, please be advised that Hanson County Dairy has decided to withdraw its water permit application. If you have any questions, please contact me. Sincerely, Lynn Jackson Schultz and LeBrun PC, Eric R. Kirkland, and up to C6.
Okay. And then on the next page, just briefly, what is that next letter?
The next letter is a notice sent from the department to Mr. Tripollet, Mr. Schumacher, the attorney, Mr. Hofer, who appears to be a pro se, Mr. Turnow of Turnow Law Office, and Brad Schnabel, who appears to be pro se, from Chief Engineer Garland Erbely at that time, from September 10th, 2012. Cancellation of the September 18th, 19th, 2012 hearing of water permit application 7239-3 Hanson County Dairy. The Water Management Board meeting that was scheduled will be canceled for that portion due to withdrawal of the Hanson County Dairy application.
Okay, so ultimately, the Hanson County never pursued this application for this permit.
Not following the memorandum.
Okay, so there was never an ultimate decision by the board of whether this application could be granted or not based on the recharge numbers in that report.
Correct.
I'm sorry, based upon the recharge numbers.
In that report in Hanson County Dairy.
Correct.
Now I want to just ask a couple questions regarding the domestic wells that are not on file. Do you happen to know when wells were required to start reporting?
I believe the initial parts of the rule came in the late 70s and were generally effective in the mid-80s.
And is there any data that you can look at, despite not having those wells on file, that you can still draw a conclusion about whether water is available or whether there's unlawful impairment?
Yes.
And what data would tell you those?
So for the availability of water, that we would, again, consider the recharge estimates that are available, the observation well data, and the appropriate withdrawal data that we have available to us. With The observation wells, that's looking at the water levels, but also taken in context of our known knowledge regarding the aquifer in general. And in terms of unlawful impairment, we obviously consider the wells on record, as well as if there are notes within the file, because there is I believe it's called Form 2A, as part of the application, that tries to note nearest other wells. We would take that into consideration if it would give us something specific that we could also reference. And there are very historical maps that may have historical wells marked on them. However, those don't ever generally include any kind of depth, so determining aquifer off of that is challenging at the very best.
So you mentioned that observation wells show you generally the water level in the area.
Yes, observation wells show the water level of the aquifer. I mean, there's obviously differences between areas. And further apart, observation wells obviously are more in tune with their specific area than each other. Again, the Dakota Aquifer is a large and expansive bedrock. So one of the natures of a bedrock aquifer is it does tend to be broadly more similar and less reactive to annual precipitation changes. So therefore, you are able to use observation wells a little further away in your analysis.
And so ultimately, even if you can't, conclusively look at every single domestic well that is drilled into the aquifer, you can still look at the observation well data and understand whether the aquifer is stable.
Yes, stable, and then within the context of other knowledge. Obviously, the Dakota, we have several of our observation wells do show declining water levels. However, that's been a historic issue that can be traced back to 1909 and is reflected by our knowledge of uncontrolled flowing wells. Now, obviously, as I was asked earlier about drawdown cone, that applies to flowing wells. There is some depression of water level nearer to more uncontrolled flowing wells. Therefore, the observation wells that are closer to more uncontrolled flowing wells tend to have more reflection of that decline.
Is that decline steep?
I would say in terms of how we look at bedrock aquifers over their history, no.
I think that's all the questions I have.
Sure.
What would constitute unlawful impairment in the context of the use proposed and the concerns of the petitioners?
So unlawful impairment, as reviewed in our technical reports, is primarily considering potential effects of drawdown in consideration of the well's proximity, but also in consideration of their construction and whether they meet the adequate well standard.
And you conclude that there's not an unlawful impairment here, correct?
What was concluded was, based on the information available, there was a reasonable probability that unlawful impairment was not expected. However, as part of our standard process in the recommendation, we do include that well interference qualification to protect those that we maybe don't know about, or if there would be an unexpected aquifer condition that would be on a very, very small scale that we would not be aware of.
And that's condition 1 of your recommendation?
That is, I believe that is qualification 1 of the chief engineer's recommendation.
And similarly, the reporting of actual amount of water withdrawn is another methodology in which the program can protect other users of water from the aquifer, correct?
That is primarily to be used for the unappropriated availability of water calculation. However, that could provide context if there were to be a question on drawdown issues. Because obviously, if 1 year someone withdrew 1 acre-foot of water, we would not anticipate, drawdown, and I'm going to make up a number with no calculations, 10 miles away. Versus if there were 1,000 acre feet of withdrawal, 10 miles away could be reasonable. Obviously, that has to be taken in context of the hydrogeology of the aquifer, as well as the well construction, as well as many other factors. So again, very broad example that has to be taken in context of the extra words that I said.
No further questions.
Petitioner, any further cross?
Very briefly, Mr. Chair. We talked a little bit about the Hanson County dairy application. Do you remember that?
I believe you and I talked about the court decision specifically, but yes.
And to walk us through that process, the applicant in that case initially received a permit from the board, is that correct?
The board initially approved the recommendation of the chief engineer, and then it was challenged to circuit court. So to my understanding, they had never actually had a permit, they had an application.
I see. And the circuit court is the one that said, because there was no recharge done, that statutorily, the board should not have granted that application, correct?
I'm gonna object to the extent that inaccurately relays the contents of the exhibit.
Yeah, I'll sustain that.
The circuit court in the Hanson County case remanded the application, correct?
Correct.
And specifically, on page 11, sorry, page 12, the court highlights what we discussed earlier, the contradiction in the board's assertion that it is not probable that the water withdrawn annually will exceed the average annual recharge without ever calculating the annual recharge or the average annual recharge. Do you see that?
I'm gonna restate my objection to the extent that inaccurately communicates the court's decision with respect to what the contradiction is that's being discussed.
I would sustain that.
So we're on Exhibit 201, page 12. The previous sentence, before it seems contradictory, is the court finds these two conclusions to be inconsistent with one another. As you read that, do you understand that these two conclusions clearly refers to the findings of fact that's referenced in this paragraph?
Restate my objection.
I'll overrule that.
I do believe it is referencing the findings of fact. If that sentence does not explicitly state that, I do believe that is the intent based on the rest of the document.
And who makes those findings of fact? In this setting, in this paragraph?
I do not know who wrote the findings of fact, but to my understanding, findings of fact are prepared, and each party has the opportunity to contribute, I don't know the proper legal term, to that findings of fact.
Sure, so the first sentence of the paragraph may help clarify this ambiguity. First, the court finds a contradiction in the WMB's findings of facts and conclusions of law relating to this issue. Do you see that?
Yes.
Then later on, it being the court, talks about how it's contradictory to assert that it is not probable and therefore. Do you see that?
I'm gonna restate my objection because I think the contradiction is the language used in that particular finding of fact and that particular conclusion of law.
I'm just gonna overrule it because the paragraph speaks for itself. I mean, maybe we should move on.
Is your understanding as we sit here today that you are required to do a recharge analysis in order to effectively analyze the 4 prongs under the statute?
My understanding is that the analysis of recharge should occur as long as there is a reasonably available information. I believe again, the reasonably available information, which is statutorily required, is what sets that exact detail of whether it absolutely must be done under every possible circumstance versus whether it needs to be done as, essentially as much as possible, while still being reasonable with the information available.
But certainly doing a recharge study would satisfy that requirement.
Depends on the quality of the study,
If
but likely.
no further questions, Mr. Chair.
Thank you. Any questions from the board?
Mr. Chairman,
Yes, Mr. Gomez, go ahead.
Mr. Mathewitz, maybe it was you or Mr. Sechi, did you say that water flowing from an aquifer to waste indicates the aquifer is seeking equilibrium, correct?
Typically, yes. What it means to flow to waste, or flowing in general, when you see that decline in the observation wells, is essentially that water will continue to flow if it's uncontrolled until either the aquifer reaches a static equilibrium where that well is no longer flowing, such as, properly constructed and well maintained, it's just broken above ground, then essentially at ground surface. If there's a failing of casing somewhere below ground, say 25 feet down, then it would likely continue to flow to waste until that water level is below that 25 feet, for example.
Okay. Then another thing about, another question, separate item, Hanson County Gatorade, they bring that up, but I've seen references to that in reports in the past. I do recall seeing that, but not all reports. Is there a distinction with this one? Why to the interveners line of questioning why that sort of a commentary wasn't included in this report? If you may or may not recall some of those previous reports, but.
So this was right as I started employment with the department. This decision came essentially a month after I started. Some of that was because the decision was immediately occurred. We had advice from legal counsel to include it in the report verbatim, even though we were essentially practicing the requirement essentially already. And then over time it became, because it's a separate court decision, if needed, we would reference it in the citation specifically and generally, but not included in the body of the text. Some to keep a 20-page report shorter, simply to save ink and paper, because we do produce a lot of reports. Some of it because it's not always, we were already doing a lot of the tasks that it requires, and therefore we did not seem it valuable enough to include it specifically.
Thank you.
Mr. Helper.
Just a minor comment. I know you said repeatedly, water flowing freely is a waste, but in drought years, it's not exactly a waste. I guess from an engineer's perspective, I get that. From a biological perspective, there's a lot of fish and wildlife that benefit. So it just, waste is not the word I'd use to describe it.
Mr. Chairman, if I could make a possible clarification. Mr. Hepler, I was specifically citing uncontrolled flowing wells. There are a number, we have permits for fish and wildlife production. There are domestic uses that they're extra water that is not used for cattle, also biologically does that. I am referencing past decisions from the board when we cite waste specifically, as well as discussions we have had with our own legal counsel in the past. Just as a clarifier to where that word comes from.
Maybe this legal counsel won't call it waste when I'm sitting on the board. Thank you.
Any additional questions from the board?
I have one, Mr. Chairman. So, the observation wells can tell us something about recharge, right?
Yes, they can.
So, in addition to the level the aquifer is at, I mean, it just is kind of like an overall snapshot of the health of the aquifer?
That is also what it does, but again, it has to be taken in the context of all of the other conditions. So yeah, it's also somewhat based, with the Dakota being so expansive, and as Austin pointed out, those observation wells far apart. Some of the more minor details, I shouldn't say minor details, some details are more localized, and so they're only reflected in the well that's very close. When taken in the context of all of them, again, because the Dakota covers most of South Dakota, then it's a broader look at the health of the aquifer as well as if there's varying conditions, because when you have that expansive, there's varying conditions. Take the example of the building. If this room is a certain temperature, I go to my office up on the 3rd floor on a hot July day, my office is pretty hot compared to this room, because I'm on the south-facing wall and I have a brick wall. My office gets real hot. For example, overall we'd see multiple temperatures, maybe I'll make a number up, 72 is the average across the building, but this room might be 68 and my office might be 84. And the observation wells, thermometer here is an observation well here, the one up there is the one up there, taken in the context that we get to the 67 average, as an example of how the observation wells, especially on the scale of the Dakota, what they show.
But in a very wet season, the observation wells would indicate a higher level, correct?
Yes. In general, you're going to see that. Obviously, drawdown, other site-specific locations may influence that. But broadly, we look for a rise, or if it were to be, such as a drought condition where we see maybe a 1-year broad decline, we might see it stabilize. With just one wet year and then an extended period, we would then see a rise.
Thank you.
Anything else from the board? Mr. Mockowitz, your excuse, release. Ms. Greco, does the state have any additional evidence?
No.
Mr. Shetter for the applicant?
I would call Nick Fitzgerald, please.
Sir, you may go take the stand.
Raise your right hand, please. You solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon, Nick. Could you please state your name and your position and place of employment for us?
Yes, my name is Nicholas Fitzgerald. Place of employment is Pipestone Veterinary Clinic on our management company.
And what are your tasks in that position?
My role is the Director of Business Development, and so I work with our farmers and clients to help identify sow farm sites and projects like this, and then ultimately develop those projects.
And projects like this, what is the this that you're referencing this afternoon?
Century Swine RE LLC.
And what is Century Swine RE LLC?
Century Swine RE LLC is a 12,800 sow farm, breed to wean sow farm.
Say what the 12,800 sow farm.
Breed to wean sow farm. And on that farm, the sows will have litters of piglets. They'll nurse those litters of piglets, and when those litters of piglets get weaned, they ultimately go to wean to market farms where they're raised for to enter the food chain.
Let me approach Mr. Chair. Yes. Handing you two documents that are marked as exhibits, 101 and 102. Give you a moment to look at those. And you would identify first what document 101 is. There's some duplication between the documents. I will explain that to the board here in a moment, but if you could please take a moment to review those, and if you could identify Exhibit 101 for me.
Yep. Exhibit 101 is our conditional use permit application to Edmonds County.
And if you would turn page 9. of Exhibit 101. And identify what that letter is. Page 9, CS 9 of Exhibit 101.
Yep, this is a letter from the Edmonds County zoning officer, Brittany Duvall, saying that our conditional use permit number 25-02 was approved.
And if you turn ahead to page CS3, this is an unsigned version of this document, correct?
That's correct.
And if I'll have you now look at 102, I apologize for the duplication to everybody. But page CS 102 is the same document that contains your signature, correct?
That is correct.
And the balance of 102, then, given that this one has your signature, would reflect what?
This is an exact copy of our conditional use permit application.
Okay. And 101 doesn't have your signature, and it's got some other documents included. What does 101 contain?
101 contains the same information. The primary reason behind the duplication there was initially when requested, I was out of the office. And so I followed up at a later date with the exact copy of the application.
But 101 includes the letter from the county informing you that the conditional use permit was granted. That was CS4, correct? Excuse me, CS9.
Yes, that's correct.
And CS10 of 101 is the letter to you from Edmonds County communicating what, sir?
That our building permit was also improved, approved, not improved. Our building permit from Edmonds County was approved.
Okay. If you then turn to CS11 of 101, it looks to be the building permit. What is the project that was proposed to be built, and what's the status of construction today?
Yeah, the project was to construct 2 buildings on the farm to house sows, gilts, and boars. The status of the project is under construction currently. At the moment, we are about 70% complete.
And the total project cost for construction purposes, as reflected in CS11 of Exhibit 101, is what, sir?
Approximately $52 million for the structures.
Mr. Chair, I would offer Exhibit 101.
The objection?
No objection.
No.
101 is admitted.
And I would also offer Exhibit 102, please.
102.
No.
102 is admitted.
Thank you. Let's talk about, as quickly as I can, but some big picture, what is the, what's the overall anticipated impact, first locally, of this proposed project in Edmonds County?
From an economic impact perspective? Yes. So this proposed farm will offer 33 full-time career opportunities for families with an average annual payroll of approximately $2.266 million. In addition, there's employer-sponsored health care. This farm will also purchase feed, approximately $4.5 million per year of feed purchases. This farm will be an end user of grain, increasing local grain demand, approximately 360,000 bushels of corn and 70,000 bushels of soybeans in the form of soybean meal. In addition, the farm will also use utilities, gas, electric, sanitation services, snow removal, lawn care, etc. Those utilities we project to be at a value of $587,000 per year, in addition to the property taxes and the sales and excise taxes that ultimately would come back through to the county, Edmonds County, through the RPP program.
Great. Let's talk about the importance of water and animal production, specifically hogs. As you have worked on behalf of Pipestone on this project and other projects, can you speak to me and give me some context around decisions on where to place projects and the impact that water plays in those decisions?
Water is a critically important nutrient. Water, air, and feed are the three most critically important nutrients to be able to operate a livestock farm. And so as we look at locating facilities, for sure those three boxes must be met for us to be able to advance those.
And one of the issues raised by the petitioners in this matter are statements that were perceived to be made that are inconsistent in terms of how much water is going to be used. You participated in the conditional use permitting process in Edmonds County, correct?
That is correct.
And you attended public meetings for that permit?
That is correct.
And provided testimony?
That is correct.
Can you speak to why one or more petitioners may feel as though you've provided inconsistent information in terms of anticipated water usage?
I'm going to object on foundation and hearsay grounds, Mr. Chair.
I'm not entirely sure what the inconsistencies are. However, the farm will, the testimony that I gave in the county commission meeting about water and water usage, I had said that the farm will utilize 4 to 5 gallons per sow per day on average. And when we apply for water rights, actually as Mr. Mathewitz had mentioned as well, we need to prepare for peak water usage. We need to build the system for peak water usage, not necessarily just the average water usage over the course of a 12-month period of time. Peak water usage, as you may expect, would occur in the warm months, the summer months. As we use more water, the animals drink more water, the staff drinks more water, and we use water to cool the animals as well. And so the average water usage would be approximately 4 to 5 gallons per animal per day. The peak would be closer to 9.5 gallons per animal per day. And so our application would have peak water needs.
And as you stand here now, do you recall what you've applied for on this pending permit out of the Dakota Aquifer?
We have applied for, I believe, 154 acre feet or 50 million gallons annually.
And there was a question earlier, and the petitioners have raised it as well, relating to more than one permit, and there's another permit pending before this board between today and tomorrow. Can you speak to why a decision might be made to apply for more than one water permit from this body?
Yes, through consult from our well driller, Stretch's Well Service. He had shared with us initially that he believed there to be a shallower aquifer. We opted to initially pursue the shallower aquifer. And so our first well was drilled into that one. We then performed a water suitability test that our veterinarians on staff at Pipestone were able to review. And they determined that the water quality in the shallower aquifer was not as suitable for livestock as we would like. And so we pursued the deeper well into the Dakota. We did drill a well. There's one existing well on the site today. And our testing on that was more suitable for the livestock. So that's why we have two.
Thanks, Nick. At this time, Mr. Chairman, I don't have any further questions for this witness.
Thank you. Lee Cross, from the petitioner.
Yes, Mr. Chair. Mr. Fitzgerald, your title is Director of Business Development at PBC Management. Is it 2 or II LLC?
2.
Is that correct?
Yes.
And PBC Management 2 LLC does business as Pipestone, correct?
Correct.
And you're a business development executive, not an engineer, correct?
That's correct.
You don't have a professional engineer license, correct?
I do not.
Or a professional, you're not a licensed professional geologist, correct?
Correct.
And you didn't personally perform any of the engineering or hydrogeologic analyses underlying any of the application, correct? That was.
I did not.
The water permit application of record here is Century Swine RE LLC, correct?
That's correct.
What's the difference or relationship between Century Swine RE LLC and Pipestone?
We have a contractual relationship, and within our contractual relationship, Pipestone's expertise is in design, management, animal health, and staffing of the facilities.
Is it fair to characterize Pipestone as the manager of the swine operation?
That's correct.
There's a third entity on Exhibit 101 CS, page CS9. It's this SFP LLC M-Century Swine. I'll let you get there, sorry. Yeah.
What page, I'm sorry?
Exhibit 101, page CS9.
One of the operating entities, one of the ownership entities of Century Swine RE LLC is SFP.
So those two entities are related but distinct?
Object to the extent it calls for a legal conclusion.
I'm gonna overrule that.
The SFP LLC is an owner in Century Swine.
Do you know why Century Swine RE LLC itself didn't apply for the conditional use permit?
Century Swine RE LLC did apply for the conditional use permit.
Do you know why Ms. Duval, the Edmonds County zoning officer, was mailing this to SFP?
Because they're one of the owners of Century Swine RE LLC.
getting into the math, or the water demand math behind the CUP application. The CUP packet authorizes a total head count of approximately 6,000 animals, is that correct?
No, that's not correct.
Okay, how much does it, how many animals does it authorize? And to clarify my question, I know there's animal units and then the physical heads of the animals. For this purpose, I'd like to focus on the latter, the actual physical heads of the animals.
The number of animals, total of 16,494.
And the total water usage for this, you said was at the request of the chief engineer to be the peak gallons per animal, correct?
We applied for more than our average anticipated usage.
Because the average anticipated use was 4 to 5 gallons per day, and you applied for 9.5 per animal per day.
That's correct.
And we can get that number by, did you divide the 154 acre feet per year divided by that 16,000 number?
We took that off of the number of animals and our anticipated usage.
Not the
Of gallons, of gallons.
So that 9.5 per gallons per animal per day, that's per animal, not animal unit.
That is correct, per animal.
Century Swine has not commissioned its own Dakota recharge study for this site, correct?
We have not.
It didn't commission a drawdown study at any of the nearby wells, correct?
We have not.
And it's not offering a numeric drawdown model at any well, correct?
That's correct.
Has Century Swine retained an independent hydrogeologic expert in this case?
We have not.
Century Swine is solely relying on the program's analysis rather than its own?
That's correct.
I saw in the CUP packet that Century Swine submitted related to this case that there was various notification letters sent to neighbors. Do you recall that?
Various notification letters sent to, as a part of the ordinance or the requirement, I believe, I reference it, but rural water was a required notification. Township road, the township, Hillside Township was a required notification. And the county highway superintendent was also a notification, a required notification.
So those aren't notifications to nearby landowners. And correct me if I'm wrong, I'm just trying to get an understanding of it. That's not a notification to nearby landowners what's going on at the well. That's more so to the county government, the local government.
That was a requirement of the county.
Has Pipestone offered a monitoring plan to any of the wells that are affected?
We have not.
Has Pipestone offered a mitigation plan for any of the petitioners or commenters that Pipestone is aware of in this case?
We have not.
Under a hypothetical, if the companion application, the 89823, which refers to the pure shale aquifer, if that's denied, the operation will rely entirely on this application, correct?
That's correct.
Does the operation have a contingency supply if both applications are denied or curtailed in any way by the board?
I'm sorry, could you ask that question again?
Sure. Does the operation have a contingency supply if either application is denied or curtailed by the board?
We do.
What's that process?
We have an agreement with Webb Water to supply water to the farm.
And so under the current proposed operation, that the 70% building has been completed, that's under the expectation that both of these applications will be approved. And Web Water, which, is it correct that Web Water is rural water?
Web Water would be the rural water provider, yes.
So under your, Pipestone's intentions are not to use Web Water for the time being if both applications are granted, correct?
Our intent would be to utilize our well water first and have rural water as a backup or a contingency.
And if the applications aren't approved, then just use the rural water or the Web Water?
That's correct.
Sort of a plan B?
That's correct.
At the sake of a 5 o'clock redundancy, is there a plan C that Pipestone has?
Those would be the plans that we have.
And Pipestone has not requested any type of conditions that would limit use during a regional shortage, is that correct?
If you would ask that question again, please.
Sure. Pipestone has not requested any sort of conditions that would limit use during a regional shortage, is that correct?
We have not talked about that, no.
I have no further questions at this time, Mr. Chairman.
Mr. Greco, do you have any questions of this witness?
I don't know.
Mr. Shutter, any redirect?
No, Mr. Chair.
All right, sir. Your questions from the board. Oh, sorry. Any questions from the board? Is Century Swine RV LLC, is that a South Dakota company?
Yes, sir, that is.
Okay. Anything else? All right, you're excused, sir.
Thank you.
Any additional evidence from the applicant?
No, Mr. Chair.
Any evidence from the petitioner?
Yes, yes, Mr. Chairman. I'd like to call one witness if the board would entertain that today. I understand we're breaching that.
It's 5 o'clock. We're gonna be here tomorrow either way. What does the board prefer?
You just got one witness?
Yes,
Proceed. Okay, let's just proceed then.
I can try to be quick too.
Okay, thank you.
Yep.
You may proceed.
I'd like to call Mr. Garrett Hines to testify.
Mr. Hines, take the stand, please.
Testing.
Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Hines, can you please state your name for the record?
Garrett James Hines.
Mr. Hines, where do you live?
I live in Ipswich,
Where'd you grow up?
on our family farm,
Where's that located?
approximately 16 miles south of Roscoe.
Where is that in proximity to the proposed facility at issue with this application? Or I'll just say the proposed well.
About exactly 4 miles southeast.
Can you explain how the land that you just referred to, how that's used today?
We run a cow-calf operation.
Your Honor, if I may approach, I have one exhibit that
You may.
Mr. Hines, I've just given you what's been marked previously as Exhibit 203 in this case. Have you ever seen this document before?
Yes, I have.
What is this document?
I believe it's off the county GIS site, but it shows the aquifer, and then the bottom graph shows elevation.
And is it my understanding that the elevation, or I'll ask, what's point A referred to on this map? It's tiny, but it's on the western part of this map.
That would be where the well application is. Now, whether that's the first well application or the second, I'm unsure. I believe it's the one we're discussing.
And then there's a black and white dotted line that goes from left to right. And then we get a B in green. Is that parcel of land where you grew up and where your parents currently live?
Yes, absolutely. It's a registered Century Farm. That quarter section is.
What do you mean by registered Century Farm?
We are registered with the DANR as a Century Farm. We are recognized in 2015.
Completely separate from Century Swine. It's a century, it's been there for 100 years.
Yep, interesting play on words, yes.
And the elevation below shows from point A to B. Is it fair to categorize that as B having a lower elevation than A?
Absolutely.
And the Dakota Aquifer is shown in addition to sand and gravel 100+ continuous aquifer. Do you see that?
Yes.
And there's also a sand and gravel 100+ discontinuous. Do you see that?
Yes.
What effect does that have as it relates to the well's impact on what I'll call parcel B?
Well, anytime you see sand and gravel, we know that sand and gravel is porous. So, containment cannot be ruled, I guess. Sand and gravel, water flows through, and water flows downhill.
And is there, I guess, generally water within parcel B that your family uses?
Absolutely.
And what is it? Can you explain it for us?
We own approximately 100+ acres of water. It's a very large basin-style slough. And then also in the quarter section, so the quarter section that's highlighted, if you go to the south and then one west, we also have a wetland area there that we use exclusively for watering our cattle in the fall as well. So combine the two sloughs, easily 140 acres of water.
And that water is used, how is that water used?
To water our cattle. We also have one of the interveners who comes all the way from Lake City to collect minnows from our slough. It's about an 1.5-hour drive. He comes all the way to our slough because of the unique characteristics and the amount of minnows that he can get from there. So we do receive a cash payment for that as well.
And that individual would be a petitioner within Exhibit 1 that was admitted earlier?
He did file a petition, yes.
And you said your family has lived there since at least 1915?
The Century Farm status, I think, is to 1914, so technically that's the furthest back we can prove is 1914. So I represent the 5th generation of our family farm.
Can you explain to me the observations that you are aware of from a factual standpoint regarding the effects of similar wells in this area that have been carried out for similar livestock operations?
Yes, I can. There's a barn, actually the wells were mentioned in earlier testimony for examples of Dakota Aquifer wells. They are approximately 81 feet deep. So they would be, if you look at this map here, you'll see kind of northeast, there's the, that's Loyalton. And then if you go further to the east is where they currently have a barn. And then almost exactly 4 miles south and east of that barn is a slough owned by Cadillacs, Ron Cadillac. He's a man in his 80s. And that slough is very obviously receding. And the other areas, the sloughs in the other areas are not. I understand that's not evidence of impairment, but it certainly demonstrates risk. But that would be almost the exact distance from that barn as our slough is from this proposed barn. However, the difference here is this barn is at least twice the size.
I have no further questions at this point, Mr. Chair.
Mr. Shitter. Good afternoon. Did you retain any engineers in helping you analyze the matters at issue in this application?
We did not retain any, no.
Have you consulted with any engineers?
Yes, I have.
Did they provide you with any opinions?
They did.
And are those opinions contained in your petition?
Of the engineers?
Correct.
No.
You had the opportunity to hire an engineer to assist you in analyzing the data that was presented as part of the program's staff analysis, correct?
We could have spent a significant amount of money, yes.
But you chose not to?
We did not hire an engineer.
You participated in the county's local zoning?
Yes, I did.
Yeah, just let me finish for the benefit of the court reporter. So you have been aware of this project as far back as last year, correct?
Correct, April 22nd, 2025.
And you submitted the petitions in this matter several months ago, correct?
Correct.
And do you have any reason to refute the data and conclusions that the Water Management Board staff have reached?
Yes, I have looked them over myself, and I have yet to see the recharge data.
Do you have any reason to believe the conclusions that have been reached are inaccurate?
Well, 34 miles away is the nearest monitor well. We're going off of data that is from 1983, 1 year after I was born. 43-year-old data, no recharge data. I do have questions, yes.
Do you have any of your own data to refute it?
To refute the engineers?
Correct.
Other than, well, what we've discussed today, evidence that there's no recharge. So to answer your question, I don't know the recharge date, and I've looked it over, and I don't know the recharge. And after all of this time, I still don't know the recharge.
But you understand that the engineers for the Water Management Board are speaking from a probability standpoint, correct?
Yes, I do.
Do you have any evidence of unlawful impairment other than what you allege in your petition?
Well, as I just explained.
Anything other than what you've provided into the record so far?
No, I can't prove impairment because there's no withdrawal yet.
Do you have, do you agree with the conclusion that there's the proposed use is a beneficial use?
If the proposed use was as stated, possibly.
Do you agree that the proposed use is in the public interest?
Could you explain the exact proposed use? Are we talking 12,000 sows? Are we talking 16,000 sows? What exact use? Because that's what I'm still waiting to find out.
As the project has been proposed, and you heard testimony at Edmonds County, and you heard testimony today, do you agree that the proposed use is in the public interest?
If it was in alignment with what was presented at the county hearing, yes. However, the statement of 60,000 gallons a day do not reflect the allocation being requested here today. Which is why we did not seek an appeal within the 30 days, because the way it was presented at the county hearing is not in alignment with what we're meeting here today.
You've had the benefit of having access to the applicant's submission for a number of months, correct?
Correct.
Do you have any reason to believe that the testimony provided by Mr. Fitzgerald is inaccurate with respect to average use and peak use of water?
Could you repeat the question?
Do you have any reason to disagree with Mr. Fitzgerald's testimony about peak use of water and average use of water?
Well, he was referring to 12,000 sows. So when we look at the number of, that's given in the manure management application from the DANR, which is the 16,000, you know, if we take that times the 9 gallons, that's 150,000. Okay, but at the county hearing, I asked the question, it all comes down to this. I asked the question, where are you getting the water and how much? And he said 60,000 gallons a day from a deep well. There's no mention of Webb, there's no mention of multiple wells and multiple applications.
But you don't have any reason to disagree with the testimony he provided today, correct?
I don't know.
At this time, Mr. Chair, I don't have any further questions.
Need more, Chuck? You good?
Does the state?
I don't have any problem.
Sure.
Oh, I apologize. Very briefly, I promise I'll be short.
Proceed.
Mr. Hines, are you familiar with any law that would require the petitioner to provide the recharge data in a case like this?
Absolutely not.
No further questions, Your Honor.
Any questions from the board? Thank you.
Does the petitioner have any additional evidence, or is that it?
No, petitioner rests, sir.
Thank you. At this time, we're going to declare the evidence is closed in this case. And I'm going to make a motion pursuant to SDCL 125-2, subparagraph D, to enter into an executive session for the purpose of consulting with legal counsel. So, let's take a recess and we'll go.
Do we have a second to the motion?
Oh.
Who made the second?
Second. All right. Sorry.
Vote?
Voice, yeah, all in favor say aye. Aye. All opposed say nay. Unanimous.
Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net. You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net.
All right, we've heard all the evidence, so, do I hear a motion to either grant or deny the permit?
Mr. Chairman Freeman, I would move to approve the, water permit application 8991-3, subject to the qualifications set forth by the chief engineer.
Thank you, Mr. Freeman. Do I have a second?
Dixon, second.
Thank you. Let's do a roll call.
Comus,
Aye.
Dixon,
Aye.
Freeman,
Aye.
Hepler,
Aye.
Holzbauer,
Aye.
Larson.
Aye. Permit, water permit application number 8991-3 is granted. With that, adjourn to the findings? Oh, findings of fact.
Mr. Cheddar, could you draft findings of fact, conclusions of law? We'll have those, hold on one second. Lost my dates. So for the findings of fact by, May 29, and then objections by, June 6. Does that work for you?
That'll work.
Wonderful, thank you.
Yes, sorry.
All right, we're adjourned.
What time tomorrow morning?
Adjourned for today. What do you want, 9?
What time was that for tomorrow morning?
9:30.
8:30?
I don't know.
I don't know.
Anybody else?
What's it?
You all gotta be back here too.
Ron, what was it? When we let out the notice, we said 9:30, correct? Or is it, doesn't matter?
I think for the first day it was 9:30, I think you can reconvene at whatever time you want, so.
That's not an assigned time for
So, 8:30 is fine with us, if it's fine with you.
John, you guys on that? Nope. All right, we'll start again, resume tomorrow at 8:30.
I'm assuming, Ron, we can leave our stuff here?
Yes.
Yeah. Amanda's gonna stay here overnight and watch it.
Absolutely not.
Bye, Leo.
Yeah.
Thanks, everybody.
No.
It's all.
Brenda, I just need to go.
Well, where do you want to,
You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net.